Greetings, my name is Rahman Maulana, as your MC for today. As I see some new faces today, I would like to give a slight overview about today's agenda. So today we're going to have two panel sessions. First panel session will be moderated by Dr. Indira Ratno Ariati, followed by the second panel session will be moderated by Dr. Fiska Sylvia. And we also have lunch break and coffee break afterwards. With no further ado, I would like to invite our first moderator for today, Dr. Indira Ratno Ariati, to come up on stage, and this forum is yours. Thank you.
Okay, thank you very much MC for the introduction. Assalamualaikum warahmatullahi wabarakatuh. Asyhadu alla ilaha illallah wa asyhadu anna Muhammadar Rasulullah. Rabbi shrah sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. Dear Professor, Doctor, lecturers here, good morning to all of you, and let me introduce myself. My name is Indira Ratno Ariati, and I'm from Faculty of Law, Universitas Airlangga, and I'm as the moderator in this session. Okay, in this session we will have 8 presenter. Yeah, okay. First presenter, I would like to invite Ibu Ria Setiawati with the title, The Indonesian Competition Law Readiness Against Data-Driven Abuse of Dominant Position in Digital Market. Okay, without further ado, I will give time to Ibu Ria for about 20 minutes.
Thank you, Ibu Temi. Assalamualaikum warahmatullahi wabarakatuh. Can see there Pak Aris and also Pak Maradona, Bu Hilda, Bu Kiki, and other colleges. Thank you very much. Hi, and also Bu Yuni, Bu Indah. Oh, now everyone waving. Okay. So my paper title is The Indonesian Competition Law Readiness Against Data-Driven Abuse of Dominant Position in the Digital Market. I wrote this paper with young colleague Zalfa Jatmiko and also Ibu Temi as a moderator here. So if there is any questions, you can deliver the questions to me and also Ibu Temi as well. Or no, yeah. Okay, next. First of all, I want to discuss about big data in digital markets. So digital markets and multi-sided platform are created by internet, and it's characterized by the use of big data as a new market power. Big data enable dominant and digital-based key players such as Instagram, Facebook, to record forecast their users' personal data and spending capacity to increase their economies of scale by tailoring updates to the user's demand. And big data become an essential market share, and its scarcity determines newer entrants' ability to enter the markets and for the exciting incumbent to survive by grappling through the fast-paced digital change. In these slides, I think that all of you here, it's nothing new. Here, every one of you is already noticed about what is big data, and also all of you, I think, have well knowledge about Google, Facebook, maybe TikTok as well. And well, in this paper, I don't want to talk about how your data will abusive by some big undertakings in all around the globe. But the issue that I will deliver in this paper is about how big data can be a dominant position and also to abusive in a market, especially in a digital markets. Let's say there's a term about multi-sided platform. In a multi-sided platform, some undertakings use their platform and do economic activity. So multi-sided platforms can be identified as a business where one undertaking offers several different products and or services to different consumers each sides of its platform that affect each other's demand due to cross-group network effect. These platforms are often signified as offering credence goods where consumers can evaluate the quality of products and or services offered after the usage or consumption. And multi-sided platform and the majority of the digital platforms in the digital markets exploit consumer personal data for their business. And well-known multi-sided platform such as Facebook and Instagram, where users acquire greater benefits from users, increased participations. The more users of social network has, the more appealing it is to their eyes. And the other well-known multi-sided platform is Google, where the increase of users from the site impacts the growth on the other as the more people use Google search engine, then the advertisers will likely gain more profits. On the supply side, multi-sided platform may exhibit economics of scale. Now, what will happen in the multi-sided platform who owns big data in a market? We will exploring abuse of dominant position in the digital markets in Google Shopping case study. Please, next slides. The case concerns the EU General Court's findings that in the Google Shopping decision as on November 10, 2021, so this case is relatively new, the United States company specializing in internet-related products and services had abused its dominant position in the online general search services relevant markets in the European Economic Area. Next, Google has developed various general and specialized search services where advertisers will pay a space to ensure that when an internet user clicks on a selection criteria, a hyperlink would automatically get activated in their ad that loads to their own websites. Recently, Google argued that first, where am I now? It did not commit an abuse because the EU Commission has failed to provide the improvements in its services, has departed from the competition and the merits. The second one is Google is not bound by the duty to supply as EU Commission failed to fulfill strict conditions laid in the banner judgment of the European Court of Justice as 26 November 1998, as its competitors' access to its services does not constitute an indispensable as essential facilities. Now we can discuss further about Bronner case. Actually, the Bronner case here. The Bronner case has three terms to determine what is essential facilities means. The first one is the facility or infrastructure in question must be absolutely essential for conducting business. This means there must be no real or potential substitutes available. The second one, refusing access must be eliminate all effective competition in the relevant market, effectively excluding all current or potential rivals. The third one is refusing access must lead to harmful consequences for consumers such as price increases or decrease in the quality of services due to a lack of competition. Now the court consideration in a Google case. The importance of traffic generated by Google's general search engine for comparison shopping services to increase advertising revenue and enhancing virtuous circle by exploring network effects. Conversely, the Google purposely decreased the visibility of those ads on its web. This could lead to a vicious circle and eventually market exit due to an inability to compete on essential elements such as relevance of results and innovations. And the second one is Google conducted capable of influencing internet user behavior. That is like to choose the first result that pop in Google traffic that cannot effectively be replaced by others. So also, Google practice is discriminatory to its competitors. It did not apply a similar standard of display and positioning to competing comparison shopping services and to its own. The second one is Google has behaved discriminatorily as it favors its own shopping services against its competitors. This behavior also leads to refusal to access or refusal to deal. What is a refusal to access means? So refusal to access is classified into three formats. First of all, unconditional refusal, which offers to when alleged dominant players refuse to access in an absolute term. The second one is conditional refusal, where alleged dominant player will open access only when its competitors agree to certain term to the dominant benefit. And the third one is constructive refusal, where access is opened only with competitors agree to comply with the restrictive terms to their prejudice and which disadvantage to them. So here in Indonesia, we have Article 25 in Indonesian competition law. In this article, that should be imposing unfair trade terms to prevent or impede consumers from purchasing its competitors' goods and services in both terms of price and quality. The second one is limiting the markets and technological innovation to the prejudice of the competition and imposing entry barrier. We also have a refusal to access in the Indonesian competition law. Although Article 19 in paragraph D is not specially tolerated for the abuse of discriminatory practices in the digital markets, the law has been designed to compasses all variety of differentiated price and non-price behavior by the way of imposing unfair terms or refusing business to offer without objective justifications. In the second one, it so means also as a refusal to access in Indonesian competition law. So in the conclusion, well, KPPU or Indonesian Competition Authority for now on still don't have the case such as Google case in EU, but at least we have these two articles for abuse of dominant positions and also refusal to deals when the big companies who own for example, has essential facilities and they cannot refuse for the competitors to use their access. And learn from Google case that finds that Google also has faced with the competition law in EU, and it means that Google have to stop its act as big undertakings who abuse of its dominant position in the markets. Thank you very much.
Okay, thank you very much for the excellent presentation. Give applause. Okay. Actually, I have a lot of questions. May I? No, yeah. No. Maybe we will discuss question and answer after the last presentation. Okay, thank you very much, Ibu Ria, for the presentation. And next, I would like to invite. Yes, thank you. I would like to invite Yanwar Ramadina Fadila from Universitas Muhammadiyah Surabaya with the title Implementation of Carbon Trading as a New Paradigm in Reducing Greenhouse Gas Emission Based on Carbon Markets in Indonesia. Okay, without further ado, I will give time to Bapak Yanwar for about 20 minutes. Time is yours.
Thank you for the recognition, moderator. Well, today's invention is tomorrow's protection, because it is better to lose 1 minute in your life than to lose your life in 1 minute. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, and may peace be upon us all. First of all, I would like to thank Faculty of Law, Universitas Airlangga, for organizing this international conference so that we can make a substantive discussion by sharing our opinions or our point of view regarding the current issues that we are aware about for now. Well, without any further ado, let's move on to the part 1 of this paper. On this special occasion, I, Yanuar Ramadana Fadila, along with my partner, Dinda Ajeng Puspanita, as my co-author, will be presenting our paper entitled Implementation of Carbon Trading as a New Paradigm in Reducing Greenhouse Gas Emission Based on Carbon Markets in Indonesia. Introduction. Climate change is a natural phenomenon that can be caused by natural variability or as a result of human activities. If you by natural variability, the energy produced by the sun can be absorbed by the earth for about 75%, and the rest will be radiated back into the earth atmosphere. The presence of greenhouse gases in the form of carbon dioxide, methane, and nitrogen oxides and other forms of gases will help to block back radiation process. In a certain amount, actually, the behavior of these gases will actually be very beneficial for the Earth because the presence of these gases can keep the Earth warm. However, if the amount of these gases is too large in the atmosphere, the gas will pollute the atmosphere, which causes global warming, which is the main cause of climate change disaster. As a sign of international community awareness regarding the climate change, topics related to climate change are made the main discussion on the Conference of Parties agenda. The conference then projects an agreement called Paris Agreement. The substance contained in the Paris Agreement projects the potential for reducing greenhouse gas emission in the post-2020 period, one of which is through the carbon trading mechanism. Indonesia has committed to reducing greenhouse gas emission by submitting nationally determined contribution or NDC document to the Secretariat of the United Nations Framework Convention on Climate Change or UNFCCC. The implementation of the program contained NDC document will be a momentum for Indonesia to improve the people welfare with various intensive efforts such as protecting and preserving forests, protecting environmental health, and maximizing programs for implementing new and renewable energy, low emission agriculture, and integrated waste management. Therefore, Indonesia needs to implement innovative funding policies so that it can optimally encourage low emission investment programs. Well, the problem that bringing up of this paper, that is the main problem that is the focus of this paper is the implementation of carbon trading has not been fully implemented in Indonesia due to the overlap between national regulation and standards set by the international convention. Through a literature review of related materials and analysis of legal documents on carbon trading regulation and their application in Indonesia, this paper proposes the need for adjustment between national regulation and international standards regarding the implementation of carbon trading schemes in reducing greenhouse gas emission in Indonesia. Well, we jump into the next part of this paper, History of Carbon Trading. The United Nations first held conference discussing about environmental issues in 1972, which was named Stockholm Conference. After going through some heavy discussion, the conference determined that countries must work together to further develop international law regarding the responsibility and compensation for victims of pollution and other environmental damage. But unfortunately, the Stockholm Conference failed to prevent environmental damage, which was marked by the occurrence of various environmental damages that were getting worse way back then. The international community continues to show its seriousness in tackling climate change through the World Commission on Environment and Development, WCED, in 1983, which was initiated by the United Nations. This conference introduced the concept of sustainability and explained the application of this discourse through the Brundtland Report, of which we also known as Our Common Future. The report reveals that the environmental impacts of activities born in industrialized countries are far greater than those born in the developing one. After going through Brundtland Report was published, the United Nations initiated a conference called the United Nations Conference on Environmental and Development, or UNCED, discuss about environmental issues, water scarcity, and alternative energy. This prompted the United Nations form the United Nations Framework on Convention Climate Change, or UNFCCC, which aims to maintain the stability of greenhouse gases in the atmosphere by reducing greenhouse gas emission. Since the global climate change negotiation in 1995 until now, judging from agreement projects, only two important achievements have occurred. Those are Kyoto Protocol and the Paris Agreement. The main principles contained in the Kyoto Protocol are the reduction of greenhouse gas by the developed countries and the ability to extend the credits for emission reduction and trade allowance and compensation internationally. In this protocol, there are 3 emission reduction schemes, which include the clean development mechanism, joint implementation, and emission trading. Even though the Kyoto Protocol was able to reduce emission in countries bound this protocol, global carbon emissions still increased by 2.6% in 2012, or around 58% higher than 1990 level. Acting from Kyoto Protocol, the United Nations and international community opened a new page in dealing climate change by agreeing Global Climate Change Agreement in December 2015, called the Paris Agreement. In this agreement, the countries can transfer carbon credits obtained from reducing greenhouse gas emission to help one or more countries meet climate target. However, what is no less important than the Paris Agreement is that this agreement requires the recording of emission without double counting. This provision is important because apart from being a solutive and new breakthrough anticipating the occurrence of double countings, which failed to apply in the Kyoto Protocol, which also become a necessity for all countries to contribute the program to reduce carbon trading contained in the Paris Agreement. We'll jump to the next part of this paper, status quo of carbon trading mechanism in Indonesia. According to the data submitted by the Ministry for Maritime Affairs and Investment, Indonesia has the 3rd largest tropical rainforest in the world. With tropical rainforest land area of 125.9 million hectares, Indonesia has the potential to absorb 25.18 billion tons of carbon emission. This is also supported by the increasingly open global carbon trade, which will make it easier for Indonesia to achieve its target of reducing carbon emission based on its commitment to contained in the NDC document. Indonesia has actually implemented a carbon trading scheme since the emergence of Kyoto Protocol. At that time, mechanisms applied by Indonesia were CDM and CGM schemes. From the CDM schemes, Indonesia has successfully implemented around 215 projects, and 37 of them have received certificate emission reduction. Meanwhile, the GCM1 has successfully implemented 106 projects and managed to reduce emission for around 329.5 thousand tons of carbon dioxide in Indonesia. Under this condition, the CGM bilateral project is alleged to be a mechanism that can support the achievement of Indonesia government to commit reducing greenhouse gas emission as stated in Indonesia NDC document, especially by using international cooperation if Indonesia design it carefully as well. The lack of knowledge regarding the carbon markets by domestic stakeholders in Indonesia and the lack of outreach to the general public in order to provide an understanding of carbon trading and its benefit for Indonesia has put the carbon trading scheme in reducing greenhouse gas emission as the last option. Furthermore, in 2021, Indonesia has launched a voluntary carbon trading trial through the Ministry of Energy and Mineral Resources in the electricity subsector. The program has the aim to introducing a mandatory carbon trading mechanism that is being discussed by the Indonesian government. Through the PT PLN Persero, this program has been participated in by 80 coal-fired power plants, which 59 of them are owned by PLN and purchase more than 75 carbon dioxide from electricity sector. The pilot program of PLN itself succeeded in reducing emission by 1 million tons of carbon dioxide assisted by 3 hydropower plants. For all its achievement, REC has received Asia Awards from Renewable Energy Market in 2021. This award is one proof of Indonesia's success in creating green service products and show leadership in the energy program. Next, we jump to the next of this paper, Regulatory Framework of Carbon Trading in Indonesia. Right after President Joko Widodo attended Conference of Party in Glasgow, Indonesia has stipulated Presidential Regulation number 98 of 2021 concerning in the application of carbon economic value, or we can call it Regulation 98. However, the regulation was issued, various concerns emerged from business actors. Business actors question whether the Regulation 98 allows business actors to carry out voluntary carbon trading on an international scale, because even though the Regulation 98 opens the opportunity to business actor to carry out the international voluntary carbon trading, the Regulation 98 does not provide details on how this trade can be implemented. Then in 2022, implementation of regulation from Regulation 98 were issued, including from the Minister of Environment and Forestry, issued Regulation number 21st of 2022 concerning procedure for implementing carbon economic value. And then the Minister of Energy and Mineral Resources has also issued Regulation number 16 of 2022 concerning the implementation of carbon economic value in the power generation subsector. Fortunately, the legal vacuum contained in the Regulation 98 has been answered through the publication of Carbon Economic Value Implementing 21st. In the regulation, business actors can carry out international carbon trading with the condition that such implementation will not interfere achieving Indonesia NDC targets. Implementation of carbon trading regulated in Carbon Economic Value Implementing 21st can be the form of emission carbon trading, or we can call it cap and trade, and the greenhouse gas emission offset, or we can call it carbon offset. In carrying out carbon trading in the cap and trade mechanism, it is necessary to obtain technical approval emission limits by PTBAE, which are the sector and subsector boundaries determined by the relevant sectoral minister, and technical approval for emission limit for business actors, which are upper limits or emission quota for each business actor during the certain period. Based on the regulation, the power subsector is 113 subsector that are part of Indonesia carbon trading ecosystem in the government strategy to achieve NDC target. In the provision stipulated in Carbon Economic Value Power Regulation 16, it's obligatory for the ministry to determine issue technical agreement which regulate following matters. First, the general limit of greenhouse gas emission at each power plant, and The last one, the upper limits of greenhouse gas emission allow for each power plant unit by a business. With those current regulations, Indonesia is the second country in South Asia after Singapore to regulate the implementation of carbon markets. Although these regulations still require several implementing regulations to be finalized in the relevant ministry level regulation, the existing regulation should be appreciated as they are quite progressive steps in the transition of Indonesia and Southeast Asia towards a greener economy. Challenge and strategy. The most obvious problem that is carbon trading pricing in Indonesia. In Indonesia, pricing of carbon reached at the point 30,000 per ton rupiah of carbon dioxide in the implementation of the cap and trade trial is considered too low when compared to the global benchmark price for around 508 rupiah per ton of dioxide. Therefore, it is necessary to adjust regulation in the implementation of carbon trading in Indonesia by adjusting global carbon prices so that the market remains attractive and prevents greenwashing practices. The low selling price will cause business actors to be reluctant and implement carbon trading schemes, even though the application of business actors, or we can call it private parties, in the carbon markets can strengthen competitiveness in the form of transition from emission-intensive production to low-emission technologies. Regarding the carbon trading mechanism, Indonesia needs to anticipate a number of matters that must be further regulated or clarified. First, Indonesia needs to design an international carbon trading protocol that will provide further insight into the mechanism and also the limit of Indonesia's commitment to reducing greenhouse gas emission to calculate the appropriate amount of emission reduction commitments. The government as the party acting as a policymaker needs to be equipped with in-depth knowledge about ways to reduce emission and the potential amount of reduction and their causes. Second, Indonesia also needs to anticipate cross-sectoral carbon trading quotas that will be determined by the relevant ministries, whether the allocation shows the concession for cross-sectoral carbon trading or trading priorities in the same sector. By compiling a comprehensive carbon trading mechanism, we can maintain market integrity from fraudulent and greenwashing practices. The conclusion, climate change is a phenomenon that cannot be avoided, considering that one of the causes is the factor of industrial activities carried out by humans. But at least the community can minimize the impact of climate change with various efforts, one of which is through carbon trading. There are still many differences and weaknesses both in the basic concept, methodology, and implementation of the carbon trading market, including those are being implemented and have been implemented in Indonesia. As a country subject to the UNFCCC, Indonesia needs to dynamically follow international trends on environmental, social, and governance issues in order to have a complete operational carbon market scheme. Although these new regulations strengthen Indonesia's position in the carbon markets, these regulations still leave ample room for further discussion regarding more detailed guidelines and more comprehensive arrangement regarding the implementation of carbon trading. And finally, Indonesia will be able to take maximum benefit from carbon market mechanism for the sake of national prosperity and provide positive added value for environment, social, and economy on international scale, especially in the Southeast Asia region. That's all for my presentation today. Thank you very much for your attention. Wassalamualaikum warahmatullahi wabarakatuh.
Welcome. Some give applause. Thank you very much for the excellent presentation, Yanwar. Okay, next presenter, I would like to invite Indah Camelia from Universitas Airlangga with the title Rights to Health for Female Refugees, Physiological Discourses on State Responsibility. Okay, without further ado,
Thank
I
you.
will give time to Indah for about 20 minutes. Indah, time is yours.
Thank you, Ibu Tami. Okay, today actually is quite special for me. Assalamualaikum warahmatullahi wabarakatuh. Very good morning. Today is basically I want to say it's quite special for me because this paper it's actually work of team, but there is me, Ibu Eni Dr. Eni Narwati. I thought she's here, but before I present here, she got a phone call that very urgent that she needs to leave out the room, and then Yahdi need to in another island, and Dr. Dina Sunyawati, she cannot survive from a lung cancer, so she passed away 5 days ago. So that's why I told you this presentation is quite special for me. Next, please. Oh, sorry. So, this paper will talk about the right to health specifically for female refugees or women refugees, with the as you seen in our title, that psychologically discourses how state responsibility or how state obligation actually should provide and should ensure the establishment of the highest standard of health set by international law and also other international setting. Why women refugees so important, and we need to emphasize into our paper only not refugees in general, but only for women refugees, as known that women refugees at the moment, it's reached about 20 million refugees across the globe, and women represent almost a half of it. So when we talk about statistics, about 10 million refugees consider they are women. So that's why 10 million people need special attention from not only from international community, also from state across the globe. I think that these women, these specific women, particularly female refugees, they seems have a high degree of vulnerability and also risk. Why? Particularly when we talk about the health issues, where not only we talk about the physical health issue, but also some degree of mental state needs to be fulfilled by a state, or particularly by a host state. What the method that we use in our paper, actually this is a legal research. However, we use a psychological discourses approach where we explain the rules and regulations to draft what the obligation set by state, and then describe the behavior of a state, how they try to fulfill all the obligation that's set by all the regulations all in entire international community, and also the idea how to improve the state behavior to provide and to ensure that a host state particularly provide a high standard of health that already stated by the law. what is refugees? Refugees is someone or a group of people who flew away from their home country to seek a safe because they're afraid of the persecution, probably because of the race, religion, ethnicity, tribe, nation, and political differences. And as I mentioned previously, why female refugees? Because this particular group, they tend to be have a high risk, particularly when we talk about the reproductive health and sexual gender-based violence, which normally will entail to physical and mental breakdowns. So that's why it's very important that host state provide the high standard of health for them. This is as I say that this is what already set by international regulation, international law about what the obligation should be, the obligation then what should do by a nation to ensure that the right of health and the right to health have to fulfill by a certain state. I mentioned about Declaration of Human Rights and ICESCR and ICCPR, non-discrimination principle under Refugees Law, Refugees Convention, Protocol of Refugees Convention, it's New York Protocol, and then the Convention of Elimination of All Form of Discrimination Against Women, 1979. So, this is the main one of our discussions in the paper, that we discuss how actually, even though there is a setting under international law, but how state interpret the obligation based. There are so many scatter rules out there, that how state actually interpret terminology of the highest standard of health. That's basically depend on certain conditions and ability of a country. So basically every state, if they have any differences or they have any ability or a specific condition, they can state a differ what already set by all international regulation. However, it needs to be stated clearly by a state. Why? Because in their opinion, not all right can be provided or will be obtained by refugees or asylum seeker, because it's very dependent on the ability of the host country, whether they able to provide it or not. However, that's we can say that's the contra, but the pros set by in our finding in our paper, that even that there is we can say that there is a gray area between it, but we can say that the state still have an obligation, the generic obligation of state, where they need to protect, to respect, and to fulfill right to health as the fundamental health, based on the UN Committee Economic, Social, and Cultural Rights, that they already declare under the Office of the High Commissioner for Human Rights, under the General Comment number 14, 2000, that they need, even though there is a gray area for that, they need at least to fulfill a full principle where the accessibility of health service, then they need to provide a good health program and made a good good medical personnel, medical equipment, standard health facility need to provide for everyone without discrimination. So that's a state by the Office of High Commissioner for Human Rights. So at least that's what a state can do and must do, even though they have something degree of what we can say, excuse that they can say that no, we don't have any ability to provide the high standard that you want me to provide for women refugees, but at least you need to provide what already drawn by international community. The conclusion is that yes, we do agree that female refugees need specific attention. Why? Because some point, it seems like not only some point, it seems like they quite vulnerable, and they also have a higher risk rather than male refugees. And also, as I mentioned earlier, that right to health, it's a fundamental right where the right to health cannot be limited or non-derogable. And the concept of the right to health for the highest, the terminology of the highest standard of health for female refugees not only assess on physical approach, but also on mental health condition. And what state or host countries should do is by provide health services start from preventive, curative, and also rehabilitative. For instance, by provide a good environment and shelter, public health program, health insurance, social security and social services. However, as I mentioned also, that it's depend on the certain condition and the ability of host country. Thank you so much, Bu Temi. That's all from me.
Okay, give applause to Indah Camelia. Thank you very much for the excellent presentation. Next, I would like to invite Bapak Muhammad Saiful Aris from Universitas Airlangga with the title State Land Rights for Improving the Sustainability of People's Welfare, a comparative study of Indonesian Constitution and the Asia continent. Okay, without further ado, I will give time to Bapak Aris for about 20 minutes. Time is yours.
Okay. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everybody. I want to talk my paper. The title State Land Rights for Improving the Sustainability of People's Welfare, a comparative study of Indonesia Constitution and Asian continent. This paper, written by two scholars, me and Pak Umar Mokhtar. So it's a perspective of combination between land and constitution. Okay, everybody? Buah duku, buah kedondong. Tepuk tangan dong. Okay. For the first time, the introduction. For the background of my paper, land actually is very important for human life. Every day we need land, so we need to regulate a lot about the land. And who has the authority to regulate the land? We can see that the state has powerful to regulate the land. You know the state? State is the organization give for the people to regulate our activities in daily life. And so, what kind of regulation providing by the state for related to the land? The state has authority to regulate and administer related to land right in the world. And what kind of land in the world? There are two kinds of land in the world. First, we can say state land, and the second one is private land. State land and private land. So there are some problems related to the kind of this land, especially conflict between among citizen and among citizen and state, especially when the state want to acquisition for public purposes. For example, when the state want to build roads, dams, market, and etc. It must be conflict between state and citizen. And then, my legal issues in my paper, there are two. My paper actually focus on the examine state authority in managing land within country based on the proceeding. And the second one, my legal issue, is does the state have land right, and what the relationship between state and agrarian resources, especially with regarding the land. And my methods in this research, my research is normative legal research. I love this method, normative legal research. I very love it. And then the second one, my approach, I use three kinds of approaches. First, I use a statute approach, and the second one, I use conceptual approach. And the last one, I use a comparative approach. My statute approach, I use national regulation in Indonesia, and then for the conceptual approach, I use a lot of approach related to the constitution. And then the last one, I use comparative approach in several countries in the world. That is, I compare to Korea, Malaysia, Sri Lanka, and the last one is Cambodia. Cambodia, maybe I will visit this country next week to get more information about my research. So this is a serious paper. And then theory of the state power for my conceptual approach. Theory of state power over land in the perspective was one I cite from the claim. State and power are two things that cannot be separated. So related to this one, so when we write this perspective, I need constitutional perspective that how to put the proper relation between state and constitution. And then, what of the key important relation between the constitution and the land right That is, the Constitution must give a protection of human right, which the government demonstrates by looking in the violation of the constitutional right. So, must be considered when the state try to take the land, especially for the private land, must be considered a lot about the individual right. Okay? And the next one, what the state function? The state function is important related to a lot of things. For example, related to defense, security, and protection. And in my paper, what the authority right to control the state, there are at least 4 points. First, granting the civil right in this topic related to for example, the property right, sovereignty right, and how building a sovereignty right and the sovereignty rights, that one. And the second one, recognizing pre-existing public right as the customary right of customary law community. In Indonesia, we can check in Article 3, Undang-Undang UUPA. And then the third, provide new public law, namely especially for management right granted to the government agency or regional company. And then the last one, the 4 important part is grant usufructory right, especially right are not limited time, are given for the implementation of the duty, such as sovereignty right for foreign perspective, representative. And then, for my short comparison, actually it's not really deep comparison because it's limited time and limited resources, because I cannot go to Korea, Malaysia, and Sri Lanka. I just use based on paper and the constitution in these countries. For the Korea is good example of giving good example of how to regulate land using land and constitution, because you know that the Korea has been performed and settled in rather in short period. Why? The system is supporting how the economy grow fastly in Korea between relation between land and its policy. And the second one, in Malaysia, based on my research, if you have any other opinion, we can share. Malaysia, land can categorize in 5 groups that register title, and then mining leases, and then land reserved for public purposes under Section 62 of the NLC, and then forest rivers and others. And the state land is a state matter. So in Malaysia, land is very important, and the state has major authority to regulate all of things. And then compared to the next one in Sri Lanka, in Sri Lanka, the regulation contain ordinance to make provision for the grant and disposition of the state land in Sri Lanka, and for the managing and the control of such land, and forest for the regulation of the use of water, lake, and public stream. And the important thing in what I can find in Sri Lanka, that president can relinquish state land to anyone in exchange for land. It means that a president has more powerful authority to regulate related to the land. And then the last one, comparison in my paper, is in Cambodia. Cambodia, Cambodia is not too far from here. That Cambodia is example has succeeded in building prosperous country based on wealth and development. Related to importing is how to combine the social and ecological responsibility. So if Indonesia want to learn, we can learn from Cambodia how to manage using land is wisely by social and ecological perspective. And then state property in Cambodia cannot be converted into individual property. So it's more be public resources. The last one, my conclusion. My final conclusion that state, given the right into form of the land right, and then the state has further regulated to clarify the relationship between citizen ownership and government. And the second one, between on my paper, Cambodia is prosperous country where social and ecological responsibility is well developed and embodied in state and land management. Because of limited time, okay. If you want to read more about my perspective, you can read in my book Ilmu Negara Pendekatan Problem Based Learning. Thank you so much and have a nice day, everybody. Thank you.
Okay, thank you very much, Pak Aris, for the excellent presentation. Next, I would like to invite Bapak Maradona from Universitas Airlangga with the title Unit Link Insurance Industry Post-Pandemic in Indonesia, Mis-Selling a Criminal Law Perspective. Okay, without further ado, I will give time to Bapak Maradona for about 20 minutes. Time is yours.
Thank you, Putemi. Assalamualaikum warahmatullahi wabarakatuh. First of all, thank you for having me in this conference this morning. It is an honor. I want to present the papers wrote by our teams. We are focused on economic crime as a part of white-collar crime as the focus of our research in the last 2 years. I wrote this paper with Ms. Hilda as an expert in insurance law. Thank you, Hilda. The title of our paper is Unit Link Insurance Industry, Post-Pandemic in Indonesia, Mis-Selling a Criminal Law Perspective. Why we wrote about insurance law but in criminal law perspective? It's inspired and motivated that in the last 2 years there are a controversy in our society. There are so many consumers, especially unit-linked insurance consumer, who file protests against the government and also go to our parliament to protest about the implementation of unit-linked insurance in our society. We tried to whether criminal law regimes can be used as ultimum remedium, of course, to deal with this problem. As ultimum remedium principles, we try to solve the problem based on private law first, and then if it cannot succeed to solve the problem, so what can be done by our criminal law system, especially after the issuing of our new criminal code. The next slide, please. Oh, sorry. So, as a theme of our conference this year, the COVID-19 crisis, of course, continues to have a significant impact to our society, including in the business of insurance. When we cite from ICIRA, for example, the pandemic affected health insurer earning by changing the pattern of payment on claims and also by decreasing investment income. So it's related to the characteristic of unit-linked insurance, because unit-linked insurance is an insurance product with dual function. First of all is protection and also investment. So the company must invest the money not only to pay the claim by the consumer, but how they try to conserve their money to the investment. And both the investment and also health system in pandemic and post-pandemic get hard or harsh influence because the insurance company must pay a lot amount of money because there are so many people affected by the COVID, and also the infestation environment in the pandemics affected by the health problem caused by the pandemic. So in the last 2 years, because the insurance environment harshly affected by the pandemic, there are a problem especially to compensate, not only to compensate the claim related to the health issue, but also the investment. Because in the unit-linked insurance, this is necessary for the customer to be well informed by the insurance agent about the right and obligation of the insurer and the insurer. The offer of investment return that is insured will receive is a projection for the future depending on the macroeconomic situation. So actually, in unit-linked insurance business, the well-informed, the education, and then the socialization about the system of unit-linked is important for the consumer. But the problem is that the insurance again do not explain the real condition to the insured, so that the insured feel cheated because at maturity or at the end of the time, they do not receive investment return as significant as those submitted at the beginning of the closing of the insurance agreement. So this is the whole in insurance system in our country right now. We can see from the data, for example, in 2009, there are more than 360 complaints and then jump to the first quarter of 2021 at the in the middle of the pandemic to 65%. Even though the complaint is not always in the perspective of criminal law, it shows that there is a problem in the unit-linked insurance. So the main problem that arises then, the existence of the alleged marketing practices that intentionally lead to mis-selling that can lead to criminal act. We found in our research that the basic problem that can lead to the criminal law is talk about the mis-selling, the practice of mis-selling when the company or the agent of the company try to sell the product of unit link. So this paper will discuss the possibility to use criminal law instrument as one of the instrument in our system to deal with the problem in unit link insurance. Of course, the methodology talk about normative, the statute and doctrinal approach, and the limitation of this study talk about the perspective of the criminal law. We try to find the possibility to prosecute not only the agent of insurance, which is a natural person, but we try to build a possibility whether the company, the insurance company, can also be criminally liable for the misconduct of the agent of insurance company. So the result will be basically insurance agreement is agreement to transfer a risk, but it should be borne in mind that unit-linked insurance products are different from ordinary insurance agreement. Unit-linked insurance is a combination of element of protection and also investment. The money from the consumer not go only to the protection of the health of the consumer, but also the investment. So part of the premium paid by the insured will be allocated as investment fund according to the type of investment that has been determined. The ups and downs of the investment value are not guaranteed by the insurer. So the insured understanding of investment management is important. So that's why in the early beginning of the presentation, the education, the well-informed is really important in unit link. When we refer to Article 251 of our commercial code, for example, that all false or incorrect notification or all concealment circumstances that are known to the insured, even though they are carried out in the good faith, are of such a nature that the agreement will not be entered into or not executed in good faith. The same condition, if the insurer knows the true condition of all these things, makes the insurance void. In connection with this principle, mis-selling can actually be qualified as an act against the law. So when we try to define what is mis-selling, this is widely used term. But there are several cross-sections that can be lead to the criminal act. So for example, when we talk about the criminal act related to the mis-selling, when the action that cause harm to the consumer for the reason they are not aware of and one, and then when the product being sold differ from what was promised. The mis-selling action generally occur are misleading advertisement or promotions, and it's committed deliberately. So in Indonesia, insurance law, for example, in Article 31, paragraph 2, actually already stipulate about the obligation to the insurance agent, insurance broker, reinsurance broker, and insurance companies. So not only companies, but also natural person among or within the companies, from insurance agent to the broker, that they must provide accurate, not false, and or not misleading information to policyholder, the insured or participant regarding the risk, benefit, obligation, and the imposition of the cost related to the insurance product or syariah insurance product. So when insurance law provide the obligation among the parties, this insurance law also have criminal law stipulation, which is in Article 45. So Article 45 criminalize or giving criminal sanction to the obligation in Article 31. It says that every person who deliberately fails to provide information or who deliberately provide incorrect, fake, and or misleading information to policyholder, the insured or participant as referred to Article 31, paragraph 2, shall be subject to criminal sanction of imprisonment for a maximum period of 5 years or maximum fine of 5 billion rupiah. So this is the lex specialis or the specific regulation related to the mis-selling conduct in insurance. The subject of this criminal law is every person. And if you look further about what is every person in our insurance law, it consists not only natural person but also company. So the company actually can be criminally liable based on our insurance law. Before our new criminal code, it is impossible to impose criminal sanction to corporation because our criminal code only recognize natural person as the subject. So if we want to implement the fraud, for example, based on Article 378 of our old criminal code, it can only be imposed to the natural person. But thankfully, since we have a new criminal code right now, after the issuing of our new criminal code, which just can only be implemented after 2026. So after 3 January of 2026, all subject definition of every person in all laws can also be committed, the crime can also be committed by the corporation. So in the future, the fraud based on our criminal code can be implemented also to the corporation. So there will be an opportunity to use not only the criminal, not only crime in insured law, but also in our criminal code to the corporation. So actually the perpetrator of the insurance crime in the perspective of insurance law and in our new criminal code is every person with his natural person and also insurance company. The question will be, in what occasion or in what misconduct corporation, in this case insurance company, can also be the subject of insurance crime. The way insurance corporation can be held criminal liable based on our system, because right now the insurance company try to mitigate that the misconduct, the mis-selling, it's solely based on the individual, solely based on the misconduct of agent. The corporation has the SOP, standard official procedure, has the regulation. They say that they try to prevent the mis-selling. Therefore, in the real case, there are so many insurance companies that try to wash their hand, that actually the mis-selling can only be committed by the natural person, the agent, the broker, not the corporation itself. But by the system actually, what is the possibility to also include the corporation in the committing of insurance crime? Based on our system that already established, based by the jurisprudence or the case law and our new criminal code, there are several ways to define the actus reus and mens rea of corporation, the criminal act and the criminal responsibility of the corporation. First of all, criminal act is taken to be committed by corporation if the act is committed by people who work or have other relation, both personally and collectively, and act within the scope of corporation or outside the scope of corporation. So if we want to also include the corporation, it must be proved that the act of agent of corporation or this agent actually has special relationship with the corporation. We don't need to prove that the agent is work officially, but when we prove that actually relationship between the director of corporation or corporation with the people and or other corporation to make the other parties act on behalf of the first party based on the written and unwritten agreement. So we don't need to prove its official relationship, but it suffices if we can prove that actually this person actually worked for corporation. Insurance industry is highly regulated industry. People who become the agent of insurance, for example, they must meet certain requirements, especially they must be certified. So it's impossible for the corporation to deny that there's not the agent of the insurance company, because the agent must be accredited, must be certified in order can sell or promote the insurance product. So it's quite easy to prove that the agent of corporation conduct is based on or on behalf of the corporation. Then, how to determine mens rea of this corporation or this insurance company based on the misconduct of the agent, for example? So in our system, in Indonesia system, at least there are 3 criteria that can be used to define the mens rea of corporation. And I can say that those 3 criteria is not cumulative. It's alternative. Sometimes we need 3 of the criteria, sometimes just need 1 of the criteria. First, the corporation gain profit or benefit from misconduct or the misconduct committed on behalf of corporation. So the fact that corporation get benefit from the misconduct of the agent can be a solid proof that actually corporation have a mens rea. Secondly, the corporation accepted the misconduct. Accepted means doesn't mean it's need the active. By the silence of corporation, it can be said that actually they are accepted the misconduct, because the corporation did not take necessary measure for the preventing greater impact and ensuring compliance with the applicable laws and regulation to avoid the misconduct. So when we can prove that actually the misconduct of agent of corporation on behalf of corporation, actually the corporation know, even though they are not ordered it, or they say that they actually have regulation, standard operation procedure to avoid, but the fact that the corporation cannot preventing or do not have due diligence to avoid or to prevent the misconduct happen, it can be a solid argument to say that actually corporation have the mens rea. So in the new criminal code, our new criminal code has recognized the criminal liability of corporation, this I already mentioned. So in the futures, the article related to the crime in insurance can be implemented to the corporation based not only from insurance law, but also from the specific regulation in our criminal code. So as a conclusion, in the criminal aspect, the perpetrator of mis-selling, both natural and also legal person, can be treated using Article 75 of the insurance law, and also because we have a new criminal code that already recognizes corporation, so our criminal code can be implemented to the insurance company in the future. The new criminal code will affect the system of criminal liability in the insurance offense by open the possibility to criminalize not only natural person but also legal person. But against criminal law is ultimum remedium when it's implemented to deal with the crime related to economic activities. We must aware that against it will affect the economic system as a whole. So we need to try whether we want to face this misconduct solely based on criminal law as primum, or let the government with the regulation solve this problem first before we use criminal law regime for this misconduct. I think that's all for me. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you very much for the excellent presentation, Bapak Maradona. Next, I would like to invite Bapak Risa Aldivianto Kurniawan from Universitas Airlangga with the title Aggravated Penalty Organized Crime Group for Illegal Drugs Trafficking. Okay, without further ado, I will give time to Pak Risa for about 20 minutes, and time is yours.
Okay, thank you, moderator. Assalamualaikum warahmatullahi wabarakatuh. Okay, my paper, the title is Aggravated Penalty for Organized Crime Group for Conducting Illegal Drug Trafficking based on Indonesian experience. These papers, from the introduction of this paper is, first of all, is since narcotic law that regulated in 2009, and since we also, Indonesian also have ratified Palermo Conventions on 2009 also, Indonesia, especially from criminal law perspective, recognize several of perpetrators, not only natural person or natural persons, but also corporation and organized crimes. From the convention, from the Palermo Conventions, is emphasize about there is a menace, unlawful menace from organized crime groups that can conduct several crimes, especially for specific crimes, to enhance their operation through criminal networkings. And one of the crimes is illegal drug trafficking. Perpetrators of illegal drug trafficking, because we also have amendment of narcotic law. Narcotic law regulated since 1976, and now we have 3 amendments. And the latest amendment is on 2009 when Narcotic Act 2009 replaced Narcotic Act in 1997. Before that, we only recognize or identify single offender and corporations. But in the newest Narcotic Law, Narcotic Act, we add organized crime group also as a perpetrators. And this is coheres with our new criminal codes that's regulated on 2023. Now, the issue regarding organized crime qualifications, when we ratified Convention Palermo Conventions, we adopted qualification of organized crimes regulated in Narcotic Act. But the adoption of this regulation or these concepts have a similarity qualification with corporations. Corporations as perpetrators of crimes based on criminal law perspective is not only a legal entities. Non-legal entities also can be qualified also as an corporation, and this kind of qualification is meet the requirement for organized crime group or mafias. And in Narcotic Act, one of element for aggravated penalty if the crime conducted through or use organized crime group. For illegal drug trafficking or narcotic trafficking, it must be conducted unlawful, and it will be have connection with the other perpetrators from the other jurisdictions, and they are use criminal network to avoiding the eradications or maybe legal law enforcements. And from organized crime perspective, most of narcotic cases is conducted by organized crime group, and they are can be operated with the coordination with the others organized crime group that exists in the other jurisdictions. Organized crime definitions, which regulated in Narcotic Acts, is similar with corporations with non-legal entities concepts. Therefore, policy for giving aggravated penalty is usually have misinterpretations, have multi-interpretations, and varies. The judges have maybe have adopt to implement this aggravated penalty to identify organized crime groups. So most of organized crime groups are they doesn't have they cannot be charged with aggravated penalty, and it will lead to another cases or maybe another target or missed target for eradication of organized crime group who are conducting narcotic crimes. Narcotic Act also give an indications, but this kind of indications usually from my research usually cannot be must always ignored by the judges to identify organized crime groups. Conspiracy who are regulated also in narcotic law very rarely to be implemented to identify organized crime. Conspiracy in narcotic law is they have a wider qualifications compared to with conspiracy that regulated in criminal codes, in Indonesian criminal codes. And in the new Indonesian criminal codes, conspiracy regulate differently with narcotic laws. The legal basis for giving an aggravated penalty, the source is from Narcotic Act, and it should be with concept of conspiracy can identify which perpetrators can be qualified as a corporation or as organized crime groups. But this is failed to be implemented because of misinterpretation with qualification of corporation as non-legal entities that became regulation in criminal codes. And from the conclusion of the research, the distinguish between organized crime and corporations should be more clear, not only in narcotic law, and it could be regulated in criminal codes. Law enforcement should focus on eradicating organized crime by giving aggravated penalty, and must use concept of conspiracy to identify or to target organized crime groups. Conspiration at narcotic law should be an instrument to identify organized crime and corporations. Conspiration at narcotics law has a wider qualifications, not only as an agreement, meeting of similar objective, but also conspiracy can be qualified as a contribution of all of the perpetrators to conducting crimes. I think that's all from my presentation. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you very much. Give applause to Pak Risa. Thank you for the excellent presentations. Next, I would like to invite Bu Hilda from Universitas Airlangga with the title Eradication of IUU Fishing in the Context of Maintenance and Utilization of Marine Resources for Development in Indonesia. Okay, you will, okay. What's your name?
My name is Yonas
Okay. Okay, without further ado, I will give time for about 20 minutes. Yeah, time is yours.
First, I would like to thank for moderators to give me time and place to give a presentation about our article. This article was written with our team under the title Eradication of Illegal, Unregulated and Unreported Fishing in the Framework of Maintenance and Utilization of Marine Resources for Development in Indonesia. This article issued by the Center for Business and Law Studies, University of Airlangga, or we call Pusat Kajian Bisnis dan Hukum Universitas Airlangga. First, let our introduce our article. Indonesia is a maritime country, which means that that the majority of the territory in the form of fuzzy waters, considering of more than 70,000 islands located along the Indonesian coastline with a large area of water. Indonesia is rich in natural resources in the form of biological and non-biological diversity stored in the source. Annually, our biological natural source in sea, there is approximately 5 million tons of total production of captured waters, rich with a production value 180 to approximately trillion in 2022. Our research methods is the research carried out the uses on an approach comparative method. The definition of the normative method is a method that aims to examine legal rules such as law based on normative cases. In addition, normative research is research that focuses on inventory of positive law, legal principles, and doctrine. Therefore, the formulation of the problem in this article is the first is the effectiveness of the problem in this, the effectiveness of the government policy on illegal and unregulated and unreported fishing incidents that arise in the territory of Indonesia. And the second is ASEAN's response to the problem of illegal, unregulated, and unreported fishing and the policies issued. Further, and our orientation of this article is to gain and maintain sustainable development goals orientation. We know that while at the same time the Indonesian government has a form of responsibility to realize the sustainable development goals SDGs point 14, namely the marine ecosystem. These SDGs eradication of illegal, unregulated, and unreported fishing is expected to optimize marine and ocean natural resources for sustainable growth and development. SDGs number 14 is conserve and sustainably use the ocean, seas, and marine resources for sustainable development. Conserve and sustainably use the oceans, seas, and marine resources for sustainable development. The increasingly adverse impact of climate change, including the ocean acidification, overfishing, and marine pollution, are the jeopardizing recent gains in the protecting portion of the world oceans. Sorry. And we can take a look in Indonesian regulation on illegal and unregulated and unreported fishing. The first regulation that Indonesian ratified is 1982 United Nations Convention on the Law of the Sea, or say UNCLOS. The first regulation of illegal, unregulated, unreported fishing in Indonesia is always related to the problem of international law. Indonesia has ratified the 1982 United Nations Convention on the Law of the Sea, or we say UNCLOS, through law number 70 years 1980. UNCLOS contained the problem related to illegal, unregulated, and unreported fishing, namely regarding to the sea territory where law enforcement against illegal, unregulated, and unreported fishing crimes by coastal states. Illegal, unreported, and unregulated fishing occurs in the territorial sea, deep sea, and exclusive economic zone. Article number 73 on paragraph and first paragraph of UNCLOS 1982 also regulates the coastal states authority to port impact and arrest and bring court any non-local vessel that doesn't comply with the laws of the country that's on the territorial sea in the exclusive economic zone. The arrest can be done by hot pursuit. And the second is law number 31, year 24 on fisheries, especially national regulations on illegal, unreported, and unregulated fishing can be found in law number 31 and 24 on fisheries. Law number 45, year 29 on the amendment of law number 31, year 24 on fisheries. Broadly speaking, the fisheries law contains various obligations in fisheries resource management, violation of vessel ownership or use in inappropriate fishing gear, pollution of fisheries resources, and criminal provision, and so on. Our results on our discussion in the article, that regulation and evaluation of illegal, unreported, and unregulated regulation in Indonesia and South Asia. In 2011, in illegal, unregulated, and unreported fishing was categorized as transnational crime by the United Nations Office on Drugs and Crime. Since 2006, Malaysia has reported 748 Vietnamese vessels conducting illegal, unregulated, and unreported activities in Malaysian waters. Illegal, unregulated, and unreported activities are also often accompanied by the other criminal acts, such as human trafficking, full smuggling, fish smuggling, and so on. Illegal, unreported, and unregulated also cause losses to coastal countries and food crisis due to depleted food availability from illegal fishing. Therefore, in Indonesia, exclusive economic zone region is very attractive to non-local vessels in their efforts to obtain fish biota illegally. Non-local vessels or foreign vessels also find it difficult to fish in their own country during seasonal change. Indonesia economic exclusive zone has cold water every year, so fish with good economic value migrate to Indonesia economic exclusive zone waters. This is the cause of many illegal fishing activities in the country marine areas. Therefore, there is an action plan. The first is resource situation management and risk management. And the second, implementation of regional and international tools. And the third, contribution of regional and multilateral organization. And the fourth, coastal state obligation. And the five, flag state obligation, port state measures. 7 is regional marker measures, 8 is regional capacity building, 8 is strengthening the management control system, and the 10, the less transshipment of goods at sea. So we will like to give a comparison in illegal fishing treatment in several Southeast Asian countries. The first is Vietnam. Vietnam, which has the ambition to become the world's largest seafood producer, doesn't want to lose market share to European Union and the United States, which are large countries and have adopted illegal, unregulated, and unreported fishing regulation to select seafood products entering their countries. Therefore, Vietnam immediately sought a way out through two aspects. The first is prevention and elimination of illegal, unregulated, and unreported fishing outside Vietnam exclusive economic zone. And the second is conducting monitoring of fish and fishery products to implement point through government decree. The Vietnam government imposes a fine of 800,000 to 1 billion Vietnam dollar for administration violators of fishing regulation who fish is in another country's territorial area without license. And the second is from Malaysia. At the RPOA, illegal unregulated unreported meeting in Malaysia in 2007, it was mentioned that there are 5 priority areas from the 10 existing areas. The first is the strengthening the management control system, natural resources condition management and lattice management. The third is local capacity building. The fourth is coastal state obligation. And the last is port state measure. Departing from the RPOA of illegal, unreported, and unregulated action instrument above, the most fundamental thing to prevent and eradicate illegal, unregulated, and unreported fishing is through regulation that become the obligation of coastal state and flag state to enforce. And the last is from the Philippines. In December 2013, the Philippines government passed Executive Order 154, a national plan of action to prevent, deter, and eliminate illegal, unregulated, and unreported fishing. The plan outlines priority action that will address the ecological, biological, and socio-economic challenge posed by illegal, unregulated, and unreported fishing in a coordinated and integrated manner with collaboration between Philippines government department and agencies. And our further discussion in this article, we discuss and analyze about illegal and unregulated fishing eradication as marine ecosystem conservation and utilization. Illegal fishing activities are detrimental to many components, including the sustainability of the marine ecosystem, which is the main problem. Illegal, unregulated, and unreported fishing activities have actually resulted to overexploitation of fisheries resources. The amount of unreported, unregulated fishing has implications for reducing the sustainability of fish and to reproduce sustainably. Not only that, illegal fishing, which often use prohibited fishing gear such as fish bombs, cyanide poison, traps, and trawls, also causes the great damage to marine ecosystem and environment. This problem will hinder in Indonesia in realizing its commitment to Sustainable Development Goals number 14 on marine ecosystem. In achieving this goal, eradicating illegal, unreported, and unregulated fishing is included as one of the 5 efforts for coastal management as well as sustainable marine economic development and marine conservation management. And the last is our conclusion. Indonesia's vast waters are a gift to the nation with the vast potential of marine resources owned by Indonesia. Indonesian waters are vulnerable to dangerous and excessive exploitation targets such as overfishing, illegal fishing, unreported and unregulated, which have the potential to threaten the sustainability of natural resources, especially marine resources in Indonesia, which include fish resources and the sustainability of the marine environment itself. Ineffective policy cannot only reduce the long-term productivity of local economics and food security of community using fisheries resources, but can also pose a serious threat to environmental sustainability. To ensure the fulfillment of sustainable development goals, number 14, efforts are fully needed to improve the effectiveness of policy implementation as well as the role of the government to create a more relevant, fair and assertive policy framework and collaboration with local communities to minimize and subsequently make progressive action to end illegal, unreported and unregulated fishing to build sustainable maritime economic system. Thanks.
Okay, give applause. Thank you very much for the excellent presentation. Now, the last presenter, I would like to invite Ibu Zahri Vandawati Humaida with the title Health Insurance in Universal Health Coverage Achievements in Indonesia, Comparison with ASEAN Countries. Oh, okay, Hilda. Okay, without further ado, I will give time for about 20 minutes. Time is yours.
Thank you, Bu Temi. Thank you for the opportunity to me. I represent Dr. Zahri Vandawati to share these topics. The title is Health Insurance in Achieving Universal Health Coverage in Indonesia, Comparison with Asian Countries. Okay, health as a right of every citizen is regulated in Universal Declaration on Human Rights, Article 25, Paragraph 1, and then Constitution of the Republic of Indonesia, year 1945, in Article 28H, Paragraph 1, and the last law number 36/209 on health. Health system, according to WHO, is an activity that promotes, restores, and or maintains health. A good health system is a manifestation of the ideals of nation in the world as stated in the Sustainable Development Goals, or SDGs. UN member targets is achieve universal health coverage, UHC, within the Sustainable Development Goals, SDGs, to promote a comprehensive and coherent health approach. Three pillars of SDGs in health in Indonesia: 1, health paradigm, service, and national guarantee. The current problem has the availability of health care facilities and quality health workers been enjoyed by poor people or community groups with low socioeconomic and living in remote areas? And the second is, how is the implementation of health insurance in Indonesia related to universal health coverage, UHC, compared to Asian countries? And the discussion is social security principles that must be met, equity and social justice. Funding for the national health insurance program for the poor is still limited. Therefore, the budget for this program is carried out gradually to achieve universal health coverage borne by the government. Healthcare policy innovation, we have 7. The first is investment in health facility made by local governments and private parties by providing and developing health facilities so that health services become a good quality. And the second, provision and development of health human resources as an important component to improve optimal health services. And then improvement of health service mechanism, and the fourth, functioning private clinics so that they can participate in the implementation of health services and can ease the workload of puskesmas. And the fifth, quality control and cost control for efficiency and prevention of waste, as well as to improve technical competence, access to health services. 6, oriented to rehabilitative, curative, and promotive preventive health service. And the last is preventive promotive health service can be done by creating green city parks so that the number of green trees can reduce pollution and stress. SDG system in the health sector can be realized. The role of the government in helping the poor to be healthy will have an impact on improving public health in a region. Improved health contributes directly to human development and economic growth. The concept of UHC, universal health coverage, is recognized by achieving the highest level of health by increasing social health insurance through the National Health Insurance Program, by increasing coverage, availability of accessibility, and improving the quality of service in Indonesia. Some positive of UHC implementation, we have 4. 1, universal health coverage. UHC is access to health services, and UHC has been shown to be effective in reducing poverty, and that innovative fiscal availability and financing are possible when policymakers have a strong commitment to strategic purchase based on cost, effective program through health technology assessment, and then evidence-based health research can be addressed the challenge of health problem. Comparison of UHC in Asian country, we have a Thailand. Thailand initiated in 1975, improved in 2002. People who are still not covered by insurance are financed through Thailand's general tax revenue, then also divide the program, universal health coverage scheme into, and then social security scheme SS for communities outside CSBS and UCS program. And for the Singapore, health insurance in Singapore consists of 3 levels of plans. Basic care, whose source of financing is held between the government and a mandatory scheme called Medisave. Long-term care of high-cost care with the source of financing is covered by the voluntary Medishield schema. And then health care intended for poor people whose source of financing is covered by a government welfare program called Medifund. And to finance healthcare beyond subsidized, Singapore provides Medisave, Medishield, Medifund, and ElderShield health protection programs. UHC in Malaysia was formed in 1990, but is currently dominated by private sector. Plan healthcare financing care financing system, and in the private sector, private health insurance is voluntary with the variable premium charged based on an individual's health status, types of health insurance, and level of coverage. A national protection program called My Salam, the insurance is provided free of charge to those who qualify and are 18 until 65 years old. UHC in Indonesia not yet able to enter the top 3 best services in Asia. For this reason, through Presidential Instruction Impress number 1 of 2022 concerning optimization of the implementation of the national health insurance program, it mandates BPJS health ministries or agencies and all regional government at the provincial and district or city level to synergy and strive optimally to ensure that all Indonesia residents are protected under the National Health Insurance Program. The last conclusion, the availability of healthcare facility and quality health worker for poor people or people with low socioeconomic groups living in remote areas has been provided with the National Health Insurance Program for the poor, which is carried out gradually to achieve universal health coverage. Funds for the poor will be borne by the government as participants in the contribution assistance recipients. And the second, the implementation of health insurance in Indonesia is related to universal health coverage. Compared to Asian countries, Indonesia is behind compared to Thailand and Malaysia and Singapore, which were first prosperous people in getting health services. For me, thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Give applause to Ibu Hilda. Now we come to the question and answer sessions. Actually, I want to invite all the presenters come to the stage because we don't have enough chairs, I apologize. So maybe to all participants who has questions, please show your hands, mention your name, and please direct your question to which presenter. Okay, first questions, Ibu Intan.
Thank you very much, moderator. I have several questions for some of the presenters. But perhaps I'm not going to spend your time for my own questions. So if one question, maybe somebody wants to have a question as well, then you can stop me. But maybe I will I will address my questions to presentation of Indah Camelia, Rights to Health for a Female Refugee, Psychological Discourse on State Responsibility. My question is, in your presentation that you don't refer specific country, which is actually, we probably should know which country that we have a lot of female refugee. And then also, do you have a social perspective and or political perspective on your research? Because if you are talking about state responsibility, then we can refer to the political perspective, especially if you talk about the refugee. And also if you want to, and also the social perspective, whether we can use this social perspective, but maybe if you talk about the health that can refer to the social perspective. So my question is, do you use both perspective? Because I think if you're talking about the psychological discourse on state responsibility, we need to know in the political perspective. Thank you.
Bu Indah, you can answer.
You want me directly to answer the question? Yes. Oh yeah, thank you, Dr. Indira, for the opportunity, and thank you, Dr. Intan, for very precisely pointing the weakness of this paper. Yes, I do agree with you. It should be when we talk about this is in intersectoral. We try to do intersectoral research. How we elaborate psychological discourses in our research, not only about our point of view about legal research or normative approach, but as I've already mentioned that we try to elaborate. We try to elaborate the psychological approach by explained the rules and the regulations and how the behavior of the state regarding the regulation, do they comply to the regulations, and then what exactly the existing challenge, and how exactly at the moment the practice. And we do comparative, actually. We do comparative with several states. It's only several states like Singapore, US, Australia, and then Malaysia, Thailand. So that's why I cannot say that this paper actually present all mostly the generally speaking about what happened across the globe about the protection or the right to health established by all host states across the globe. But yeah, we try to do it. But and your second question about the social approach, yes, we haven't do more research about the social approach because at the moment it's very in the first stage of this paper. We try to do intercollaborating between not only law, so we still try to do very basic psychological approach for that. Thank you so much. I hope it answered the question.
It is very interesting paper basically, but maybe the title is a bit trivia, because if you're talking a psychology, you're talking about the person.
Yes.
But you're talking about the state.
Yes.
You're talking about the institution.
Yeah.
Yeah. If your research is about the morally approach or political approach, that's probably correct. Yeah. So that's why I'm asking whether you are putting a political perspective in your research, and actually in that political phenomena you drag the line about how its effect psychologically to the leader, for example, in the country, in the state, to apply that responsibility. That's maybe the good point, but that's why I'm asking the question. But that's okay.
Thank you.
Yeah, that's good answer. Is there any question for other, or I can keep asking?
Maybe, is there any questions? Okay.
Okay, thank you so much, moderator, and good morning. Now it's almost noon time. So my name is Indra Wahyuni. Thank you for the presenters that provide a lot of insight for us today. I would like to discuss, raise my question to the paper Yanuar Ramadana Fadila, which talk about carbon trading as a new paradigm. So my question will be so simple and short. Looking at the carbon tax that failed to implement twice and even still failed to now, do you think the carbon trading in Indonesia, especially carbon market, will be successful, and whether that's also discussed in your paper, to what extent, and the challenges, barriers that could prevent this carbon trading mechanism in Indonesia. And I see from your presentation, perhaps would you mind to elaborate? Do you suggest a solution for that? Is that any kind of mechanism that's suitable for Indonesia learning from elsewhere? Thank you so much.
Can I actually
Yes.
answer the question? Okay. Thank you for the question. Maybe as one of the world's largest emitting and coal producing countries, Indonesia is actively decarbonization actually. So because the forest area data in Indonesia, the data shows that forest area in Indonesia classified into 3 different function detail with 68.8 million hectares of production forests to 29.7 million hectares of protected forests and 22.1 million hectares conservation forests. If from data above is with the scenario of scaling price of carbon credit worth until $5 per ton in the carbon market, that the potential income from this trade could reach around for about 8,000 trillion rupiah. So with that fact, actually I think the carbon trading mechanism is a new paradigm from we know that the carbon tax and its obstacle has finally failed to bring the reducing greenhouse gas emission actually in Indonesia. I think that's all, and thank you.
Okay, thank you very much. Any questions? Okay, Bu Intan.
Okay, thank you, Ibu Moderator. Yeah, I have questions for the presenter, and but I'm not going to dominate this floor. Yeah, but this maybe Prof. Bruce have also a question. Yeah, but I will because it's a bit important for me. I would like to address the question to Muhammad Saiful Aris. Just one question. Yeah. You are talking about the state land rights for improving the sustainability of people's welfare under the Constitution. My question is about whether the rights that is been given by the Constitution is also the right to rehabilitate the land that, for example, destroyed by the earthquake, by any but let's say about the natural disaster. That's my question.
Yes, thank you for your really good question, Bu Intan. Yes, actually, in our constitution in Indonesia, what I mean that the constitution is also regulate for the right to get good environment. So it's stated in our constitution. I forgot the article. Is in around 20H. Yes, the right to get the environment. So my paper focus on actually the state has power or authority to regulate a lot of things about how to use the land. But the problem is usually how wisely use the investment and the environment. Usually most developing countries focus on how to push the investment for economic purposes and not focus on how to protect the environment. But when we study in my paper, I read only based on secondary resources because I'm not yet go to Cambodia yet. in Cambodia is the example of good country, how wisely use the state perspective between the economic and the environment. And I think we need a study for this one. That is my my answer.
So basically, your paper is not exactly talking about how the rights that given by the Constitution is also the right to rehabilitate the land that actually, for example, degrade from by natural disasters, right?
Yes, my paper is not focused on the rehabilitation of the environment. I just want to compare how the proportion of the state, how wisely using the state for many purposes. My paper focused on several countries, Korea, Cambodia, and what is I forget? Korea, Cambodia, and then Indonesia.
Sri Lanka.
Oh, Sri Lanka. And yes. Thank you. You pay attention my presentation. And then it's not focusing on the rehabilitation of environments. Maybe next international conference.
Thank you very much. But I also have some questions. Just 2 questions again.
Okay.
I would like to address my questions to the Hilda Yunita Sabri, the eradication of IUU fishing in the context of maintenance and utilization of marine resources for development in Indonesia. In your paper, in your presentation, that you are talking about the illegal fishing treatment in ASEAN as a comparison. My question is, do you analyze this comparison treatment based on the regional studies? Because you're talking the regional studies, you're talking about how each country in that region not only giving implying a policy per se, issue a policy, but also implement it. And then to what extent the compliance, that's regional study. And then you're not only focusing on one country. So my question is, do you think your research is using a regional studies perspective?
Okay, who's going to answer? Hilda or Anon? Okay. Where is Anom? Not here? Oh, okay. Maybe Bu Hilda, want to answer? Okay, next questions.
Maradona. Okay, you were, maybe you can clarify this for me. I'm not I've done some criminal law in the past, and obviously I'm no expert on Indonesian criminal law, particularly the new criminal code. Now, the new criminal code has provisions which capture corporate liability, corporate criminal liability. And in your presentation, you suggested that, or you stated that if the corporation does certain things, then it can be held liable, okay? Now, where in the corporation does that criminal decision have to be made? Is it at the very top of the corporation, or is it anybody in the corporation?
Thank you, Bruce. I'll give you an answer about that, but first I want to tell a story about our criminal code, right?
Okay.
Because we are inherit our criminal code made by the Dutch in 1881. So the old criminal code that are still under influence of von Savigny about the legal fiction. So until now, until today, our criminal code we still implement the old criminal code that only recognize only natural person that can be criminally liable. But in our system, the recognition of corporation as the subject of criminal law happen outside our criminal code. Therefore, right now, if we want to prosecute insurance company, we can only implement the stipulation directly on the insurance law, because in insurance law, every person is described as both natural person and legal person. So in the future, if the new criminal code actually is already issued by the parliament, but we have a transition time. It's just only 2026 that the new criminal code will be fully implemented. In that criminal code, every person is natural person and legal person or corporation. So theoretically, in the future, in 2026, all criminal sanction can be imposed both for natural person and legal person. So in the system of corporate criminal liability, in one misconduct, there is opportunity first to prosecute the physical actor, the natural person, but because they are directly involved, muscular movement directly involved to the misconduct. Secondly, by the system or regime of corporate criminal code, there is opportunity to prosecute corporation as a legal entity. Our system already has the system established by our criminal case. There are several landmark decisions, even though in criminal code right now has not recognized the corporation as the subject, but in case law and also the law outside the criminal code, we already have the system how to determine the criminal act or actus reus and how to determine mens rea of corporation. Our system already have the several criteria. And then by this criminal code, the criteria will be more clear because we already have in general system criminal code how to establish actus reus and mens rea, also in laws and also in case law. So the third parties that can be prosecuted in the system of corporate criminal liability, first physical actor, secondly corporate corporation, the third what we call in Dutch language as feitelijk leidinggevend, people that actually involve, or we can show the actor intellectualis. So there is three parties that can be prosecuted based on this system. So in the future right now, because when we recognize corporate criminal liability in this insurance crime, for example, there is a possibility or opportunity to prosecute the beneficial owner or the actor intellectual behind the misconduct. Because right now it's only the physical actor, only natural person. The corporation try to limit that the misconduct actually committed by natural person, by the agent of the corporation. Even though the corporation itself enjoy the profit and they actually know and understand the activities, they try to keep their eye closed, but actually the benefit or the profit from the misconduct go away to the corporation. That's why we fight against this corporate criminal liability based on that system. But in our criminal code, there is a guiding sentence in our new criminal code mentioned that if the prosecutor want to prosecute corporation, they must have like a policy or try to make or waging whether if they want to prosecute corporation, it will benefit the society or not. Yeah. It's like the Posner system about the economic analysis of law, because corporation has strong influence in our community, right? Because one of the characteristic of economic crime is also the ultimum remedium, the way that criminal law actually exists as the moral condemnation, but the implementation should be by the end of the process, not primum remedium in the very beginning of the process. I think that's all. Yeah.
So in other words, even if the activities or the actus reus is committed by somebody fairly low in the corporate structure, the corporation can be held criminally liable?
Yeah, because like in UK, for example, you are implement what you call identification theory, right? Based on the Tesco Natras case, right?
Yeah. Which is absolutely crazy.
Yeah, because of course. Yeah, because, for example, there is actually vicarious liability, the act of again, but in the UK, based on identification theory, they implement the alter ego doctrine that the concept of corporation can only be derived from the directing mind of corporation. Exactly. But in our system, actually, it's broader. Yeah. It's broader. We implement the system based on the Netherlands. It's about the reasonable attribution theory. Yeah. It's about the social context. So the judge will have a large authority to interpret whether actually in social context this misconduct actually committed in the spirit of corporation or in the spirit of individual. Yeah, yeah. So it's broader than the system in identification theory. But compared to UK, for example, even though in corporate criminal liability implement the identification theory, but in FCPA, in Bribery Act, the UK still implement the vicarious liability. Yeah. So that's the different treatment about the general and the anti-corruption law in UK, because it's quite difficult if we try about the identification theory, right, Bruce?
Exactly. It's given the Tesco case, it's almost impossible in the UK to convict a corporation for any sort of misdeed, and in fact, to get around that, for instance, in cases of sort of severe industrial accidents, the UK has developed or imposed by statute a new corporate manslaughter provision, for instance. And so the barrier is too high, and I think setting it lower within the corporation, as Indonesia has done, is quite a good thing, because it therefore incentivizes the company to keep an eye on and monitor the conduct of its employees and other agents, because if there's no such incentive, as you said, the company can wash the hands of all the responsibility and profit from the ill-gotten gains of the criminal activity.
So I can mention that in our system right now, it's quite easy to establish the actus reus and mens rea of corporation, but the system will be. The important thing about this corporation system is about the defense of corporation. Yeah. So that's the important key for corporation to avoid prosecution when they have a certain defense why that misconduct happened. Yeah. That will be the next issue in the future.
An option for a due diligence defense. In other words, we took all necessary precautions to monitor the behavior of these low-level employees, but in spite of our very careful monitoring of them, they still acted as criminals.
Yeah, that's true. Then that can be used by the insurance company to avoid the prosecution because as I already mentioned, that insurance system is highly regulated. Yes. The way they implement the law, the way they train the agent and try to make a system that can be used as a guardian for the corporation for the misconduct of certain agent. I think that will be the important thing for the corporation to avoid a prosecution. Right. Yeah, I think that's all.
Thank you.
Thank you for your question, Bruce.
Okay, thank you very much. Is there any questions? Yes.
Question is not answered.
Huh?
My question is nobody answered my question to the Yuhira Yunita Sabri.
Yeah, maybe she's not here. And Anom is not here. Sorry.
Okay. Because the paper is very interesting, but it's missing something that actually needed to be to improve the paper, the research. That question. But it's okay. I will give the floor.
Okay. Next questions.
Test. Good afternoon, everyone. Well, probably in comparison to everyone in the room, I'm still a student majoring in law, but I have several questions here. 2 questions. First question is, of course, regarding the paper of rights to health for particularly female refugees, done in the psychological aspect, right? My question is regarding the obligation to help these refugees that is backed by, the regarding convention of the human rights that have to be protected because these are refugees. I think there is several backgrounds that should be implemented in the paper, such as why refugees exist in the first place, right? Because one, refugees, most likely, most of them are moving because their original country are having conflict, for example. Yeah, indeed, it doesn't make any less of obligation for host countries to help them. But then my question becomes, is the obligation to help particularly female refugees much bigger than their own obligation to protect and help and prioritize their own citizen from the host country? Because I think I understand from the paper that the ability to help is based on the ability of those countries to, if they have the economical advantage, to be able to provide the services necessary. So if indeed they do not have that capability, are they still obliged? I'm saying if they are economically not yet great, are they still obliged to help these refugees to be able to give them the necessary services they need? That's all. Thank you.
Thank you, Ibu Indira. I will answer directly, actually. So yes, on the complete paper, we also provide historical background why there is a refugees, why we need to pay much attention for female refugees. As I already present that half of 20 million refugees at the moment are female. So that's why the group of female, particularly for female refugees, it needs special attention, because the abuse or probably the health issue that will affect it for them. It's not only physical but mentally, but somehow mentally, not only mentally, because we talk about reproductive, and somehow we also need to consider sexual gender violence. So that's why, because of the complexity of the problem that will affect their health state, their health condition. So that's why this project actually only emphasized for female studies. So we try to capture the high risk, the degree of high risk. So that's why we try to emphasize more in particularly female refugees. And then for the state obligation, yes, as we also emphasize that there is obligation set by international setting, that there is obligation of state to protect, to respect, and to fulfill. And if I may refer your attention to all regulation that I already presented, there are so many. But some point, if we we want to, if we want to emphasize under those many rules, at the very important terminology is that the higher standard, it emphasizes the higher standard of health. The higher standard of health, it's quite like it's in the sky for some state, particularly for developing country. So it's like in the sky for developing country. So that's why if under the comment of UNC, under the comment of one of UN bodies, they need to provide health programs, a good health facility, blah, blah, blah. And it feels like it's so high. So if there is any choices for them, they, in one extent, they need to provide a good services for the refugees that we know exactly they are foreigner. Or do we need to treat them better than our own citizen? I don't think so. So that's why the gray area of that in our paper, we provide the evidence basis that actually, even though there are very high requirement how to provide a good high standard based on international law, however, everything it's depend on the state capability and condition. So if they cannot provide a very high standard, at least they can provide the minimum standard. However, it needs to be stated clearly. So it needs to be stated clearly, or at least they already have the program, even in a minimum standard. However, it probably will challenge by a very wealthy country because they have a very high standard. But at least for a certain country, which are they are developing country or probably less than developing country, they try to provide and they try to comply what already set by international law. Thank you.
Okay, thank you very much. We still have time. Okay, Bu Intan. Next questions, Bu Intan. Oh, Bu Indri.
My question is to Indah, why only female refugee? If you refer to the refugee, there is other gender, that if you refer to gender study, and then if you refer to the refugee law is a neutral, right? And also health law, and then from the WHO is also neutral. So that's the question. Thank you.
Honestly, my honest answer is because it's quite sexy study, a quite sexy article to write. Because like, yeah, we talk about someone, we talk about the group, it's very, need to be protected. We talk about refugees, and it's very specific for women, so that's why our team decided it quite sexy idea to explore more, because in some extent, they need specific protection and they need specific attention. So that's my, as you say, that's my honest answer. Thank you.
Okay, thank you very much. Bu Indri?
Okay, thank you, moderator. Allow me to raise one more questions to a paper which written by Pak Riza Alifianto. So the paper is quite is very interesting. It's about aggregate penalty organized crime group. So I would like to stress that I'm not an expert in in a criminal law, but because in your presentation today, you talk about Indonesian experience, but this criminal organized crime group, especially for illegal drugs, should be like transnational, is beyond the border. So, for example, there's a drugs come from other countries, go to Indonesia, or perhaps from Indonesia to other country with various methods. I saw a movie which is put it inside the body as well. So there's a various method. In your research, which is very interesting, in your research, do you apply a comparative method that seek internationally what's happening if it's transnationalism? And do you see there is a role of international criminal justice system in UN, internationally, for example, ICG, to deal with this problem that can cross across the countries? So is your research until that limit, or you only see from Indonesian perspective? Because if you're only looking from Indonesian perspective, it will be a bit too small, I guess, because when you talk about transnationalism crime, especially drugs, you have to reach out from various legal structures. I think that's all. Thank you so much.
Okay, Pak Risa, you can answer.
Paper is emphasize on how we can learn from Indonesian perspective to avoid it the multi-interpretation about qualification of organized crimes. For the recent regulations, especially for aggravated penalty for organized crime, only regulated in narcotic law, and aggravated penalty for organized crime didn't regulate it in our new criminal codes because Indonesian criminal code only adopted several crimes that's regulated in criminal codes, but not amendment the narcotic law, especially for the concept and element for aggravated penalty. Organized crimes, because they are use criminal networks, so they maybe have relations with the other perpetrators cross borders or from the other jurisdictions. Our narcotic law have a legal basis to proceed narcotic crimes that located in outside Indonesian jurisdictions. But when we use these regulations, it will be against the sovereignty from the other states, because we will violate jurisdiction from the other states to proceed crimes that exist in other jurisdictions. But we also have legal basis for that. But in Indonesia, only emphasize and only focus on narcotic crimes that exist in jurisdiction of Indonesia, especially conducted by organized crime groups. Lot of improvement.
So from your explanation, I can get the point that there's a lot of loopholes and also a legal reform that needed, especially in drugs law, because there is, I think that's also a good point. If you agree with, it's a good point to you put for your suggestions for legal reform, because it's obviously a problem. Thank you, moderators.
Okay, thank you very much. Last questions, Bu Intan. Amnam is here, so can you repeat your questions?
in your presentation, you're talking about the illegal fishing treatment in ASEAN, right? So, in my opinion, if you are talking about how one country to another country imposing or implementing something like treating something, it means that it comes to the area of the regional studies. Yeah, for example, from geographical to law, like for example between, let's see, if you are talking about IUU fishing, talking about the marine resorts, talking about the sea area. So my question is very simple. In analyzing the comparison of the illegal fishing treatment in ASEAN, did you use a regional studies in this?
Yes, in this article I use regional studies from several countries, not all Asian countries. I use from Vietnam, Philippines, and Malaysia on how they treat.
The regional study means that you are comparing the policy and the compliance of the policy and the impact of the policy. Like for example, you said comparing Malaysia and etc.
Yes.
Yeah. You are not comparing about law, but not about comparing the policy, because you're talking about the treatment. Treatment is a whole. It's a policy and compliance of policy and the impact of the compliance of policy. So my question is, if you're working on the regional study, then you are comparing, let's say the easy way, the simple, let me simplify it. You are comparing the policy of Malaysia, how to treat the IUU fishing, and the compliance of the policy and the impact of the compliance of policy with the Indonesia, for example. That's my question is, did you use that regional study? Because if you're talking about regional study, that's a regional study. If you just comparing Malaysia law and Indonesian law is legal comparative study, which is actually, if you are talking about legal comparative study, you are talking about the constitution and the implementation of the LARES. But that's my question is about, because you are saying comparison on the treatment of the IUU fishing. That in my mind, treatment means policy, implementation, compliance, and the impact of the implementation. That's under the regional study. That's my question. Whether the research is using that?
My research only on policy studies and how they reflect IUU fishing, not only by their regulation, but I'm not doing my research yet into the statistical impact. Like you see, statistical impact, because I found it the different years, different agenda, different program from each nation. So I cannot compare those statistics. Like I cannot compare because it irrelevant because it's different programs. But that's something that I want to underline on Indonesia, Malaysia, Filipina, and Vietnam policy is Filipina, Vietnam, and Malaysia policy is the first. They have a specific program and illegal, unregulated, and unreported fishing. In each year, like for example, in 2022 in Vietnam, they use the assistance by the third parties. It's called US aid, fish right. They use the sustainable fisheries partnership with the third parties, and that impacting with regulation. It's been not only regulation, and that's what I want to say, that Indonesia only implement the law and regulation, how to manage law, regulation, and the implementation and local community, and use enforcement force like what you say, TNI and such, but don't have specific programs each year, and don't collaborate with other parties. That.
Okay, thank you very much. Time is up. Thank you to all presenters. Thank you for your insightful presentation. We hope that we can meet again sometimes. And to all participants, this is the end of the session. Thank you for your participation and see you next time. And I will give back to our MC. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Thank you so much, moderator and all presenters. And next agenda is we'll kindly invite all participants or the attendees to have a lunch break in room 303. And we kindly remind that we need to be back here in the same room at 1 p.m. sharp, since we are going to have the next session. It is the second panel session. So that's it. Enjoy your lunch break. Thank you so much.
Tes, tes. Sorry, just confirm. Anybody represented by Ibu Sriwinarsi? Okay. What is your name? Angel. Okay. I would like to mention some name to know your attendance in this room. Mr. Joshua Hari, Mr. Russell Davis. Oh, okay, yeah. Because the time is shown into 1 p.m., so we will start our session on time. Excuse me, for the presenter, please sit in the first chair. Sorry, what is your name? Russell Davis. Oh, okay. Is it okay if you want to be the first speaker? You're not ready yet. Okay. Yes, because other presenters haven't sound yet. Because we will start on time. So we will be waiting for other presenter. Do you want to be the first speaker? Okay? Yeah, okay, thank you. Okay, ladies and gentlemen, welcome to the offline panel session, the 4th International Conference on Law, Governance and Globalization in 2023. My name is Fiska Sylvia, and I'll be your moderator for today's session. Thank you for your attention and participation into the conference based on information from the committee. In this session, we have 6 presenters. To all presenter and participation in today's online session, we will have 15 minutes to presentation. We encourage you to take notes and hold on to any question you might have until the end of each presentation. And the presenter will aim to answer the question during the allocated presentation time. Please don't hesitate to contribute with your insight. Now it's time to our presenter to deliver the presentation. Our speaker for the first time is Miss Angel. She will present, represented by Ibu Sri Winarsi from Universitas Airlangga Indonesia. Her topic is about a legal framework for handling land degradation in Southeast Asian nation based on the United Nations Convention to combat desertification from upstream to the downstream. To Miss Angel, please, the time is yours. Miss Angel, you have already give the USB? Okay. Yeah. We start in the 1 EM, past 6 to 1 EM, so we will be finished at about 1 past 20, yeah.
Okay, good afternoon. Thank you, Ma'am Fiska and my esteemed colleague. My name is Angelica. I'm an undergraduate student here, and I'm going to be representing Bu Sri Winarsi because she can't attend today's conference. Today I'm going to present about the paper entitled A Legal Framework for Handling Land Degradations in Southeast Asian Nation based on the United Nations Convention to Combat Desertifications. This is the study from upstream to downstream. And today I stand before you all to shed light on a critical issue that has become a global agenda for a better future. Of course, it is sustainability. Since 1992, national governments have been actively engaged in sustainable development with the United Nations, spearheading the initiative through the 17 Sustainable Development Goals, or as we call it, SDGs. The SDGs encompasses 17 indicators that aim to achieve harmony between ecological, economic, and social politic aspects. Among these vital indicators, the 15 SDGs concerning life on land and terrestrial ecosystem is often overlooked in favor of other indicators such as no poverty and industry, innovations, and of course infrastructures. However, these non-optimizations of the terrestrial ecosystems indicators may lead to severe consequences, leading to like poor water quality, environmental degradations, lack of healthy food, and diminishing agricultural land. Neglecting this indicator has also affected other SDGs, like access to clean water and sanitation, responsible consumptions and production, clean and affordable energy, and decent work and economic growth. The 15th SDG's objective is to manage forest sustainability, prevent land conversion to desert, and halt land degradations, and also combat a lot of biodiversity extinction. Recognizing the importance of combating land degradation, thus making countries in Southeast Asia ratify and accede to the United Nations Convention to Combat Desertification, or we call it as UNCCD. However, implementation has not been fully optimized, which leading to significant amounts of damaged land in these regions. Next. Okay, to address this issue effectively, it is very crucial to understand the legal framework for handling land degradations in Southeast Asia and develop a comprehensive approach based on the UNCCD principles that I mentioned earlier. Several regulations exist right now in these individual countries, such as the Land Development Act and the National Park Act in Thailand, the Environmental Quality Act and the Land Conservation Act in Malaysia, and also Article 30 of Law of the Republic of Indonesia, number 37 of 2014, on soil and water conservation in Indonesia. But still, it is very important for us to, because those regulations to align with the UNCCD guidelines. Nevertheless, to achieve these optimal results, cooperation and coordinations among Southeast Asian nations are very essential. The UNCCD, established in 1994, provides guidelines and arrangement for combating land degradations at national and regional levels. The convention considers the diverse conditions and needs of each region, emphasizing international cooperation for sustainable development objectives, which the formulations of a legal framework for handling land degradations in Southeast Asian countries based on the UNCCD principles should address several key aspects, which the first, of course, the assessment of vulnerable areas, which Southeast Asian nations must identify and assess areas vulnerable to desertifications and droughts, considering diverse factors like climate, topographies, land use, and also socio-economic systems. And also, there is also addressing resource pressure, which heavy pressures on natural resources for livelihoods must be tackled, as it really directly, contributes to land degradations and water scarcity. Addressing issues like poverty, health, nutrition, and food security also is very crucial. The third is enhancing institutional capacity. Countries need to strengthen their institutional frameworks to effectively combat land degradations and address associated challenges like migrations and demographic dynamics. Also, international cooperations. Southeast Asia countries should seek and participate in international cooperation to pursue sustainable development objectives related to combating desertifications and mitigating the effects of drought. By analyzing the legal framework for handling the land degradations in Southeast Asian nations and incorporating UNCCD principles, we aim to formulate a comprehensive approach that optimizes land conservation efforts, protect ecosystems, and foster sustainable. So therefore, we have two problem statements here. The first is, how is the legal framework for handling land degradation in Southeast Asian countries? And next is, how is the formulations of a legal framework handling land degradation in Southeast Asian nations based on the UNCCD, or the United Nations Convention to Combat Desertification. Next. Next, okay, thank you. The first is the comparison of legal frameworks for handling land degradations between Southeast Asian countries, and the limitations of the research is between Indonesia, Thailand, Cambodia, and Malaysia. The significance of addressing land degradations cannot be underestimated, as it directly correlates with our shared commitment to protect the planet and ensure its sustainability for current and future generations. Within the Sustainable Development Goals, or SDGs agenda, namely the 15th goal, focuses on protecting and restoring terrestrial ecosystem, managing forest sustainability, combating desertifications, and halving land degradations and biodiversity loss is very important. As I have mentioned before, many Southeast Asian nations have taken steps to implement policies to combat land degradations, and each country has established its own legal framework to address these pressing issues. Indonesia, for instance, ensures legal certainty through Presidential Regulations number 111 of 2022 concerning the implementations of the achievement of Sustainable Development Goals. Indonesia has also ratified the United Nations Convention to Combat Desertifications, or UNCCD, which plays a pivotal role in guiding the nation's efforts in handling soil degradations. Similarly, in Thailand, where it also has ratified the UNCCD and has incorporated soil degradation management into its Land Development Act 2551, which outlines restrictions on land use and requires permission from the land administrator for clearing yield land for various purposes. Cambodia has also ratified the UNCCD and employs the Kingdom of Thailand National Action Program for combating desertification to address these land degradations. Cambodia's Ministry of Agriculture, Forestry and Fisheries, or MAFF, leads the country's efforts in soil degradations response. Malaysia, through its National Land Code, has also adopted the UNCCD and managed soil, such as regulations in Malaysia vary based on the territories of Peninsular Malaysia, Sabah, and Sarawak. Despite variations in the legal frameworks, common threads still be found in addressing soil degradations. This includes integrating sustainable practices, restoring natural resources, conserving ecosystem, and engaging stakeholders at multiple levels. Next. Additionally, Southeast Asian countries have aligned their national development policies with the SDGs, incorporating the goal of addressing soil degradations into their medium-term development plans and other national strategies. However, while legal framework exists, but their effectiveness depends on proper implementations, monitoring, and enforcement. International cooperations and sharing of best practices are very essential to tackle this global issue collectively. Evidently, that is why a proper formulation of a legal framework for handling land degradation based on the UNCCD is needed. So, the second problem statement here is formulations of a legal framework for handling land degradation in Southeast Asia countries based on the United Nations Convention to Combat Desertifications, or UNCCD. So, let us understand the significance of the UNCCD and its relevance in Southeast Asia and why we should formulate a new legal framework for handling these problems. Next. To better comprehend the UNCCD's role, let's explore its key provisions and relate it to land degradation management in Asian region. The definitions of land degradations encompasses the reductions of loss of productivity and complexity in various types of land, including rain-fed cropland, irrigated cropland, range, pasture, forest, and also woodlands. This definition helps standardize the perceptions of land degradations across the regions. Also, cooperations and information exchanges are very essential elements for handling land degradation. The UNCCD encourages countries to integrate and coordinate the collections, analysis, and exchange of relevant data to better understand and assess the process and effects of drought and the desertifications. Collaboration at the sub-regional and regional levels, involving bilateral and multilateral arrangements, helps share knowledge and experience among these nations. Next. Also, national action programs play a crucial role in addressing soil degradations. Countries are encouraged to involve affected...
Your time is 3.
Okay, thank you.
Minutes only.
involve affected populations and local communities in their preparations current programs for combating desertifications, aid in designing effective strategies. While the UNCCD offers valuable guidelines, there are certain shortcomings that need to be addressed. The document may be perceived as more of a guidance rather than a legally binding framework, allowing countries to interpret policies according to their specific characteristics and circumstances. Therefore, to enhance the effectiveness of the UNCCD, Southeast Asian countries can take the following steps. First, establish a consistent legal ground. Second, strengthen the national action programs. The third is foster regional cooperation. And last but not least is to explore financial cooperation through collaboration with financial companies in the region to secure funding for combating these problems. Therefore, in conclusion, the formulations of a legal framework for handling land degradation in Southeast Asian countries required a unified efforts and effective cooperations. By aligning national regulations with the UNCCD, creating strong national action programs and promoting regional collaborations and exploring financial cooperation, we can pave the way for a sustainable futures and protecting our precious land for generations to come. That is all for me. Thank you for your attention and good afternoon. Thank you.
Okay, give applause to Ms. Angel. What an interesting presentation. Maybe some of you want to ask question, but later, yeah, please hold on, because we will hear another presenter will be will have presentation for the second presenter. Okay, thank you, Miss Angel. You can go back to your seat, please. The second presenter is Bapak Teddy, because because he asked me, because I have information that he will have a flight scheduled for the ferry, because he have a limited time to land to go to the flight, go to the Bandung, because he is from the Sekolah Tinggi Ilmu Hukum Bandung. Okay. He is go to pray. Oh. Yeah, but it will be takes 20 minutes. Okay. Okay. The next speaker, who will be the Bapak Raden Edi, or sorry, what is your name, please? Oh, the first speaker, Bapak Joshua. Okay, please, who is Bapak Joshua? Oh, okay, please go to the place we have already provided. Actually, because we have already mentioned your name, but you haven't arrived yet. So the next presenter is present Bapak Joshua Hari from Sekolah Tinggi Hukum Bandung, Indonesia. The topic is about good governance in climate change policy toward net zero emission through renewable energy project. I'm sorry, your time is only 15 minutes.
Okay, good afternoon, everybody. We will present our paper with the title, The Good Governance in Climate Change Policy Towards Net Zero Emission Through Renewable Energy Projects. We write with our team, Mr. Joshua Hari, Mrs. Neti, and me, Teddy Agustinus, and Mr. Darwin and Natunda Vico. Next. Oh yeah, please next. Okay. Okay, first of all, the identifications according with Paris Agreement's approach, policy and energy, that states should complete to control climate change and energy policy needs to be adjusted as the Netherlands use the absolute basin and carbon intensity in China approach in climate change mitigation, but Indonesia still uses business as usual in current condition. And then fossil fuel and renewable energy dependency in fossil fuel has a major contribution in current Indonesia energy policy. Coal dominating in economic sector by stakeholders, and it's shown the needs coal in hike in industry. It makes the energy transition by renewable energy project is still left behind. Next, please. So, how about Indonesia's approach to climate change and energy transition policy? First, Indonesia contributes and expresses the NDCs into political will, and the first NDC of Indonesia in 2016 with the target, set the target the should achieve in is 29% to 41%. In next year, in last year, Indonesia has exchanged the NDC from 31% to 43%. That means that Indonesia is aware of the serious impact of climate change. Also, the government of Indonesia use President's Regulations number 112 year 2022 about acceleration of the development renewable energy for electricity supply, and the political will is implemented into legal policy and regulation that confer multiple sectors. With many sectors, legal policy becomes more complicated, especially when engaged energy sector. However, contradictions still exist based on renewable energy and the reliance of fossil fuel. Incoherent the regulation under legal policy about climate change make the transition becomes more difficult to achieve the target. Next. The commitment of Indonesians based on Paris Agreement for implementing into a policy, the first, practice energy efficiency, the second, greater use of renewable energy, the third, electrifications of industrial and household process, the fourth, electric transportations, and the fifth, carbon capture and carbon storage or carbon tax in, and the principle will apply in 5 sectors as follows: agriculture, industrial process and product use, IPPU, forest and other land use or value, energy and waste. We can see that the national energy policy, energy availability for national needs, and the supporting regulation for national energy policy, that's energy conservation. The second priority of energy development, the supporting regulation is environmental and safety, and utilization of national natural resource. Supporting regulations is price, subsidy, energy intensified, and energy national reserve. The supporting regulations is access and infrastructure for society and energy industry. Next. The climate change action and NZA, we can see that the vertical coherence, there is law, governance regulations, president's regulations, and ministerial regulations. For the horizontal coherence, different regulation at the same of arrangement, the substitutions, difference regulations, similar arrangement, and the complementary and the antagonistic. We can see that what is the challenge and opportunity to realize climate change mitigations through policy for NZA 2060 need action plan on this aspect. For the follow, that the aspect of reforestation, peatland restorations, and land management needs the finance, energy, and waste. For the finance, no more substitution petrol, and for the energy efficiency and waste is circular economy. And peatland restorations is using carbon tax, renewable for energy, and waste using the reduction liquid waste. Next, please. Yeah. In climate change mitigation policy, regulation in energy sector and follow are important, but there are regulations that, especially in follow, as barriers to accelerate and improve capacity climate change mitigation. Furthermore, there is no defined leading sector and ministry to settle conflicts. It occurs among different agendas from multiple aspects and sector. Yeah, in the future, it is better to choose one sector or ministry and put additional authority to set the policy into a legal framework. Purpose of this proposal is the chosen ministry should lead and integrate interests and agendas among sectors and aspects. Also, additional authority is needed to make it is an arbitration function. Next, please. Yeah. In order to achieve NZA to support NDC Indonesia's climate change action policy, through energy sectoral has to implement a clean project that environmental zones collaborative actions is important between development and developing country. Also, the European Union member states has already started a movement to establish clean project that is relating to climate change as known as a green growth. The renewable energy project is intended to reach national determined contribution or NDC that has been set is 31%. Like I say in the first time, and should overall with the sectoral. Next, please. We can see that the project of business as usual and emission reduction for its sector energy.
Okay, and then the next slide, please. Okay, so from the projected, next one. So from the trajectory, I would like to comment about Indonesia commitment about the greenhouse effect. So Indonesia commitment of greenhouse gases based on Paris Agreement is 29%, and the target is in 2030. And according to the regulations, Indonesia focused on a national electricity company that set up an action plan with two scenarios. The first scenario is about optimal scenario. It is about low carbon scenario. It aims to reduce of greenhouse gases with the target 23% of the contribution of renewable energy project. It is stimulated if the scenario works. Approximately 710 billion tons of CO2 will decrease from business as usual, and it needs additional action such as co-firing coal with biomass as the source of coal-firing power plant or CFPP, and design a new type of power plant. The new type of power plant will replace the current power plant in the future to phase out the coal until 2030. This is an example of a renewable energy project with minimum effort to achieve the target of NDC. The second scenario is low carbon, and this scenario will decrease 998 million tons of CO2. With this scenario, it is not only contribution of 23% from renewable energy project, but also will cut the level of utilization of coal into 59% by 2030. Next one. So, Okay, so the advantage of optimal scenario is greenhouse will go down faster in a year, and the advantage of low carbon scenario, it will get bigger target to reduce CO2 and push the use of coal into 59%, sorry, but the acceleration to reduce the greenhouse gas is slower compared to the previous scenario. Hopefully, the combination between two scenarios will create a carbon intensified approach and combine it with absolute basin approach, and it will make Indonesia will achieve the target faster. And then, next slide. How about approaches to climate change approach? The first one is absolute emission reduction targets. The second one is business as usual. The third is emission intensity reductions. The last one is project absent of greenhouse gases emission targets. I would like to address the first one as absolute basin, and the third one as carbon intensified. The Netherlands used the first one, and the third one is used by China. So this is the comparison between carbon intensified and absolute basin. So basically, China is a country that has different approach to climate change mitigation. China limit and reduce carbon to control climate change. The purpose of carbon intensified is the government of China will use a policy to control the activities within the territory, and will measure how much the activities will create carbon. On the other hand, absolute basin is an approach from the Netherlands. The government will make a policy, and based on the policy, they will measure if it's the target or the limit is enough, or it needs more steps to slow down the increase of the temperature. And from the legal aspects, we can see that the Netherlands has an impact because they doesn't depend on the legislation only, but they use the climate change litigation to make a better policy. We can see from two cases. The first one is Urgenda case. The second one is Royal Dutch Shell versus Milieu Defensie. And result and discussion. Environmental management does not mean management of the environmental, but management of the activities within environmentally tolerable limits. However, government in developing countries such as Indonesia tends to use constitutional law as a legitimation for development. The second one, it is about state responsibility with the context of human rights. And the third one is about the Paris Agreement. Paris Agreement is an international provision, but however, it lacks of legally binding aspects. So the commitment itself, it depends on the country, how much they can contribute to the reduction of the emission. And I would like to skip this one because I don't have much time, and I would like to go to the conclusion. Conclusion is, dependency in fossil fuel has a major contribution in Indonesia current energy policy. As a consequence, transformative legal policy is important in energy transition to fulfill NDC towards NZE. Energy transition policy should be directed in a legal framework. It will create a fundamental legal basis to be implemented in renewable energy project. And the second one, to deal with Indonesia approach towards climate change, we should combine approach from China and the Netherlands to make it faster and achieve Indonesia target towards NDC and NZE. Thank you.
Thank you for Bapak Joshua. Give applause to our presenter. So, is it enough time to go your flight? Your flight is? No. Oh, Pak Teddy, it's okay. 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 Thank you. Because the topic is very interesting. I saw Ibu Indira is also maybe have many questions about the renewable energy. Yeah, because CS has the same interesting topic about research and study. Okay, let's go to the third speaker. We have Mr. Russell Davis. He has the same topic with Bapak Joshua already. Pak Teddy or Pak Teddy Agustinus. Pak Edi huh? Sorry, because we don't Pak Edi. Oh, okay, please Pak Edi, because I don't have your information about you here. Yeah. Okay. Yeah. Come on. What is the time of your flight? The time? Yeah. Okay, come on. Maybe about 10 minutes is okay? Okay. Because I don't have your data here. Yeah.
Okay, thank you for the time to present this topic, regulating investment based on environmental protection to achieve environmental sovereignty, the land use of Indonesia context. So we explain about the phenomena. Next slide, land degradation, especially for crude palm oil impact, is caused from overexploitation and deforestation. The solution is about how we review the regulation and sustainable practice. The fact that 4 billion hectares in the world is have suffered on land degradation. In Indonesia, 16.38 million hectares. This is very crucial for our land use roadmap. Yeah. Next. So from Marcel Silvius in IPS Congress, he said that the point of the land degradation important that make wrong situation is about weak governance and also regulation. Next, please. The theory, we have several approaches that related to the regulation, especially in law and economy discipline. Is not definitely have economic regulation typology. So Stigler starting the theory that regulation are issued, were regulated and designed primarily for benefit, and in return regulators gain political and financial support to continue the administration of government. So Stigler just said the cost and benefits analysis, not consider the welfare state and what is the sovereignty defined. Yeah, in later Rio and Stockholm declaration. Yeah, while Posner argues that the economic approach must have, the implementation of investment must have a rationale of law, yeah, that strengthen the analysis of economic arrangement in general. Posner added the existence of equilibrium-based theory of regulation, which states that regulation is the product of coalition between regulated industry, where industry groups under regulation. This like group interests that have influence to decision maker to make a regulation and policy. And Mayer have criticized, yeah, Stigler theory that regulation can also cause obstacle for the company to enter and exit the market. Next slide. So the Cedric Dupont analysis also mentioned that the legal system, the state as the main source of law enforcement and regulation of the legal system. He mentioned about the legal system and mentioned about the regulating of environmental sovereignty. And Lon Louis Fuller also give some emphasis law of system, regarding the environmental law. Yeah. So in the legal and law basis, environmental law already defined clearly. Yeah. Next slide. So this is Stockholm and Declaration and Rio Declaration. I only define 6 clauses: sovereign rights, and environmental responsibility. Next, please. So sovereignty on environmental, Mahajan said that the right of sovereignty is basic right that must be obtained by humans. Yeah. So Robert Alexy also added that human rights have choose to environmental rights. Yeah, fundamental right is like supporting for the how human have right to maintain and to earn the environmental clarity. Next slide. So in Rio Declaration also mention about the sovereignty and the state principle 13 and principle 1, yeah, in Stockholm also mentioned about the sovereignty. Next slide. This is fundamental, yeah. I must explain, but okay, the time is short, yeah. August Reynis
the last
defined.
slide, please.
Next please, yeah. August Reynis defined permanent sovereignty over natural resources. This is example how government, how institution of a government must define and must control the right of people to get the environmental sovereignty and environmental sustainability. Yeah. Number 2 is exploration, also must controlled by government. And the last is how the capital and the governance refer to international law.
Maybe you can conclude your conclusion because you have just 3 minutes left.
Okay.
Yeah, okay.
Too short, yeah, because this is.
Yeah.
Okay. After studying previous description, because if we discuss about Indonesian law, this is bad failure. If I define in regulation palm oil impacted to land degradation, many rule that not comply to international standard land of use and spatial planning. So okay, we skip this important thing, but the conclusion, okay, in the challenge, second page in the last.
The second last page.
Yeah, challenge. So
the challenges.
Challenges. Competing interests between sectors. Yeah, this is a problem. Yeah, also intense competition for land and corruption, but I'm not clearly define how corruption running. And the third one is lack of compliant ISPO. ISPO is a certification. This rules in our regulation is wrong. Yeah. So many land degradation is coming from the certification and the standard. We don't have a standard of land of use. This the new intention about the regulation and law in Indonesia. Also, the fourth one is immature legislation, and the last one is regulation process, weak, yeah, from science to policy. The conclusion, yeah, totally, we cannot make institutional framework and legal framework clearly if we have act and legal not clear. Yeah, so I think this is our homework, yeah, for government to make a regulation more clearly from the technical, from the science to policy, must inline and not infiltrate by investor or by CPO owner. Thank you very much.
Okay, with excellent presentation here, because we have already known, but there are several rules in international standard for this industry, but Indonesia not really comply to the regulation. Maybe we can, because Pak Edi have a flight in the limited time, maybe we can directly go to the question and answer session for Pak Edi. Maybe the participant or the presenter wanna have any question for Pak Edi? Okay, please mention your name and your affiliation. The committee, please, Mike.
Okay, thank you so much for the opportunity, Madam Moderator. Please introduce, my name is Indra Wahyuni. I would like to share, this is interesting presentation, Pak Edi, although you haven't mentioned the problem yet on your presentation, but I'm interested on this, the last challenge that you provide. Would you mind to refer back
please,
to
the second last slide?
Yeah.
So the operator?
Yeah, I mean one page before this.
Yeah.
Yeah. So I'm interested in how you can see this palm oil problem. As we know, we have this kind of problem for a long time, and we also have a ban problem from EU that said, "Oh, you're not having a good plan, environmental plan just because of palm oil." So, how you put regulation process from science to policy as a challenge? Should is it, what is that? I mean, can you elaborate it on? Because that is so interesting for me. When you put a regulation process, it should be from science to policy, not the otherwise. Thank you so much, Pak Edi.
Yeah, thank you, Ibu. Jadi, the process to make a regulation from the literature and from the academic review is not consider about the problem in detail. Yeah. Also, how the investor, especially in crude palm oil, not give the real situation. Yeah. So the academic also have a wrong contribution. Yeah. The academic people not define clearly in Indonesia, especially in Sumatra, why and what the land deforestation coming from CPO, crude palm oil investment. Yeah. So from that, academic people or university or institute must have some probing what is the problem, what is the situation, how and why. Yeah. So from that, the academic contribute to the Senate or contribute to the government. Yeah, this is the process. Yeah, how science, yeah, and the literature and also the phenomena collide. Yeah, so if academic see that this is problem, so the academic must integrate how to make a solution and how to make act regulation give to the Senate, yeah, to control and to avoid impact from the land degradation, yeah. So this in the Undang-Undang Perlindungan Lingkungan Hidup, ya, UU PLH, ya, itu that's many inconsistency, ya. If the history of the we see the history how the Undang-Undang PLH make many lack, many mistake process because many notes in 3 notes in this article, yeah, how the process, yeah, to make policy, to make regulation is not in line with the situation in the crude palm oil side, yeah. So we, as an academic, yeah, we have good position to support government to make this situation good, have good, proper condition later to solve the problem, yeah, I mean, in the act later. So we must together see the situation and give the contribution, literature, and also the phenomena from other country, give a recommendation, and then the Senate will make the draft of act, yeah. So we have together support the government. This my explanation. If you see the article, very clear that how the process is wrong, based on drop explanation. You can see Stephen G. Dryhoff how the regulation is wrong. This very clearly defined from the upstream to downstream, from the thinker to the executor. There is some lack. Process, yeah.
Okay, so yeah, there are many our duty as an intellectual, yeah, to supervise our regulator, yeah, how to make the right regulation in our country, because yeah, now it's trend to corruption by law. So not law to the law enforcement to the corruptor, but the corruption make regulation for his action. So that's the fact in the recent years. Okay, give applause to Pak Edi. And safe flight, Pak Edi. We will see in the other event of our event. Thank you so much. Okay, for the next speaker, we have Mr. Russell Davis. Are you ready? Okay. He will cater about topic Indonesia Waste Management Construct in a Legal Perspective, Comparative Study to Singapore Waste Management Regulation. So you have research in Singapore. Okay, so that's very interesting.
Timer ya, so saya timer.
Yeah.
Okay.
You have 20 minutes.
All right. Good afternoon, everyone.
I am Russell Davis. I'm here going to be the presenter of our paper here. So basically, my lecturer, Madam Jennifer, and of course a partner, a colleague of mine who are working on a paper. Unfortunately, they're not able to be here, but of course, I'm going to present it all for you all. So this is the title of our paper, Indonesia's Waste Management Control, if we are going to actually do a comparative study between our own government with the actual rules and regulation and enforcement laws that exist in Singapore. So yeah, if you guys have the blue book, I think our abstract is at page 32, and it might help you in understanding the abstract of the actual paper. Next. So, regarding the content of our presentation today, this is the inherent content, so I'm just gonna skip ahead. Let's head into the abstract of our paper. Next. Yeah, regarding firstly, the goal is we want to actually analyze the laws, the improvement of waste management in Indonesia by looking at other countries that is doing waste management in a way that maybe is much better, or at least statistically better than our country right now, which is why we chosen the actual example of being Singapore, because we feel like Singapore, even when they are a challenged country, they are very small, yet they are able to accomplish so much. So the regarding hypothesis, right, we have to engage on them. There has to be the existence of an active effort to develop effective regulation to reach a sustainable way of actually managing our waste, our trash and whatnot. So the inherent keywords from the extracts are indeed waste management, waste regulation, and of course the sustainable development goals. Next. So this is a bit of a background of the actual statistical data regarding waste management that is currently happening in Indonesia. The first point, regarding Indonesia's production of waste, or the amount of waste that exists in Indonesia in 2020 because of COVID and everyone is in their houses, there has been a major spike in waste in the amount of 32.82 million tons of waste in the year 2020. Thankfully, in 2021, there is a reduction, which it came into 21.88 million tons in 2021. Now, the composition in Indonesia's waste, we can see from the pie chart, we can see in the pie chart there is 58% is coming from kitchen waste, meaning that it comes from household. 14% is indeed plastic, 9% papers, probably from schools and whatnot, and the 19% is other type of waste management that is not being classified. Now, second point here, to achieve maximum results, it needs that there is participation not only by the government, but the actual society itself. So people inherently, civilians and whatnot, there has to be active participation from society, because most of the waste that is in the pie chart, we can see 58% comes from household. It came from indeed the society. So thirdly, in order to reduce the amount of waste that is piling up in our landfills, in our management facilities, there is requirements that we are going to be involving various parties, not only the government, not only regulators or enforcers, even we have to engage upon society itself. And the fourth point is the inherent example of comparative that we're going to have, which is we're comparing ourselves to Singapore law enforcement, that they have succeeded, I think, in building a waste management system and regarding their regulation and implementation in a way that is much more effective than our own country. So that's why we're able to say that we believe that Singapore have succeeded in building a waste management that's successful, because inherently Singapore does have a rate of 56% waste total in Singapore is indeed being successfully managed, successfully processed to make sure that it doesn't leave much more pollution. Next. So this is regarding the research method that we used in our paper. First, we use normative judicial research, where we are comparing solely just the laws, the regulation between Singapore and Indonesia, and the actual statutory approaches that both countries had. Secondly, the classification, how we classify legal materials and other literatures, other journals that is relevant to the inherent problems of waste management, not only in Indonesia, but basically in the whole entire international world. And thirdly is we're going to use research method of analysis, where we are going to compare the rule of law between Indonesia and Singapore solely to see the actual differences. And fourthly, of course, the conclusions about what the Indonesian government can do to build a better waste management system that can indeed process waste in a safe manner and in a much better rate and in a much more successful rate than it is right now in the actual current of reality. Next. Yeah, regarding the discussion that happened in the team between me and Madam Jennifer and Nadia, there was discussions regarding regulation versus reality. So we cannot only measure something just solely from whether or not the regulations are good, but of course we have to compare it whether in reality it's implemented well. And of course the second comparison and discussion is that we are going to discuss regarding in comparison to Indonesia and Singapore. Next. So this is the actual laws that is currently managing most, if not all, of the actual waste management that is happening in Indonesia. First, there's Article 53 of Regulation of the Minister of Public Works on Public Housing at Republic of Indonesia, number 3, year 2013, Government Regulation if need of Republic of Indonesia, number 81, year 2012, Law of Republic of Indonesia, number 23 of the year 2013, Law of Republic of Indonesia, number 32 of the year 2009, and lastly, Law of Republic Indonesia, number 18 of the year 2008. This is the inherent regulations that are currently in play and are currently in the government and already out there and is being used to indeed control the actual waste that we have and manage the actual waste that we have. Now let's compare it to then what happens and what are the results of these regulations, which is the reality side of things. Next. Yeah, so regarding the actual end goal or the actual things that are happening in reality, happening to us in the day-to-day of basics. One, regardless of the laws, whether it's good or bad, corporations that are doing the management of waste are indeed lobbying our government, and they have exerted their influence to the responsible authority. This means that there is power imbalance where sometimes these corporations are able to outpower our governments. So the government of Indonesia is competing with basically corporations that are inherently doing the waste management systems here in Indonesia. Now, this is the first reality. And secondly, the actual landfills that we have in Indonesia, right? In Bantar Gerbang, we reached a maximum height of 50 meters in an area of 104 hectares of land. This is literally mean that the landfill mostly in Indonesia is already filled to its maximum capacity. That means that most of the waste that Indonesia have is not properly managed and properly processed to not go into landfills. They stop in landfills, and that's what's currently happening. And thirdly, there are many opposition coming from the public regarding obstacle in the form of the land costs and lack of appropriate price. How right now land costs are rising and whatnot, meaning much more challenges for these companies or people to be able to manage their waste. Now, next. Now, regarding the point 4.2, regarding comparison between Indonesia and indeed Singapore. So, first stage when a waste does exist in Singapore, they do grouping of waste. This means that one, if this is actually dangerous material waste, they will put it into the proper facilities. Oh, this is plastic waste, they will put it into solely plastic processing plants and whatnot. This doesn't happen in Indonesia because there's no inherent grouping of waste right now that is properly done in a good way. This means all of the waste that's coming into landfills are just processed in somewhat of the same facilities. This means that there is no sectionizing sectors of multiple types of waste, which makes it less effective. And that's why in Singapore, it's much more effective because there's ones that are only for very hazardous waste, ones that are for plastic waste, and ones for like household waste, to make sure that all of this facility can only focus into that particular group of waste to ensure that the effectivity then reach a much higher rate of effectiveness. Now, this is the comparison of the first thing. Secondly, the disposal facilities licensing. What's great about Singapore is they're very strict on which companies and which facilities have the actual license to actually process waste. This doesn't yet exist in Indonesia. This is still very, very somewhat in the gray area right now in Indonesia, basically, because most facilities even exist without permits, without license, that creates not a good amount of effectiveness when they are actually processing the waste. So the inherent second point here is talking about they're very strict on who have the right and who are able to have the ability to process all of the waste. That's the second point. Regarding the third point, penalties or fine for violation. In the violation that we mean is when a facility is indeed processing waste and they do not have licensing. In Singapore, they're able to give you penalties or fines for those violations. Even for those companies that have license and are doing waste management, when they're doing it not correctly, also would have penalties and fines for those violations also. So this is the inherent comparison of the actual strictness of the government between Indonesia and Singapore. How in Singapore, if you're wrong, you're actually going to suffer the consequences, the penalties, the fines for violation. But in the current system of actual justice system in Indonesia, there's very much loopholes that corporation can actually exploit. I think from the presentation before regarding unit-linked insurance, how, oh yeah, a company cannot be prosecuted for criminal and whatnot. So this is all of the loopholes that's mostly being used by corporation to dodge certain prosecution. And lastly, this is the actual result of what Singapore have, how there is 57% of their total waste is successfully recycled in the year 2022. And in 2023, it's subjected to reach upon 60%. This means that they're recycling and managing more waste than their actual waste that are going into their landfills. This is very good for a country that's much smaller in comparison to Indonesia, a country that is a literal small island, but they're able to actually successfully create regulation and actual implementation that can successfully recycle 57% of the actual waste that exists in Singapore. Next. Yeah. There is 3 aspects of the Singaporean management of facilities and laws that eventually causes them to be able to succeed in waste management. The first is the regulation and the strict control and the actual socialization of their regulation. So this means that the citizens have obligation to pay a fine if they do not obey certain regulations, which I think is very strict and very good for a country that's small, because inherently this causes more of the citizens to be incentivized to process their actual waste. Oh, I would rather process my waste in comparison to receiving a very large amount of fines when the government find out that I do not recycle my waste, for example. So that's then, we're incentivizing our people to then would rather spend a little bit more money to process their waste in comparison to getting that huge fines. Secondly, the actual facilities and permits that is given towards the actual facilities is given from the Centralization of Waste Management Authority. They have a special authoritarian government that is only job, which is the actual waste management. I think this is very good because that means they're going to be much more focused on the aspect of waste management. They're not going to be focused on regarding the effects of with environment or whatnot, just solely focus on actually processing waste, which is very good because this means that there is one body that we can trust to actually have a waste management in Singapore at least. And thirdly, how Singapore is able to then succeed is that there is producers' participation. How any time that there is a factory that are actually making products, for example, they have to participate in waste management. They have to pay certain things to make sure that the actual waste management will go well, to ensure that their products, even when the products is harmful, even when the products is not harmful, could be actually managed, waste managed properly in Singapore. So this is all of the three things that is very well done in Singapore. So yeah, it's already 17 minutes, 3 minutes left. Next. So the conclusion of our paper is three aspects of actual waste management. First, to achieve proper waste management in Indonesia, we need legal substances such as regulation that is very disciplined regarding waste management. So the actual laws that we're actually going to make have to be then implemented strictly. Secondly, the proper team to manage and facilitate the process of actually waste management. So this is like basically enforcements. If indeed our, for example, our criminal law are very great, but there is no policeman, it's still useless. So inherently, enforcement is some kind of a police specifically only for waste management. And we're going to make it like people that watches the actual waste management process that's happening in Indonesia. So, and thirdly is regarding the culture of Indonesia, how we want to engage into the society's wanting in actually obeying the rules and following the integrated waste systems. Because if we create great laws, we have good enforcement, but our people do not respect those laws. Our Indonesian people do not want to follow those laws. Everything and all of our efforts would be meaningless. So thirdly, we have to create socialization of why it's good, for example, to do waste management, why it's not expensive, why it's affordable, why people doing this would make them healthier, for example. So that is all for my presentation today. Thank you for the opportunity. Thank you, everyone.
Give applause to Mr. Russell Davis. It's a very excellent presentation because we have already know that Singapore is a fine country. Yeah. So the Singapore is really strict to how to manage the waste. Yeah. Okay. Please, Ms. Russell Davis, you can go back to your seat because we will discuss about question and answer later. Yeah, thank you so much. Okay, the last presenter is Mr. Martin B. Salinding. Is Mr. Martin B. Salinding have attended to this room? Mr. Martin Salinding? Oh, I think there is no Mr. Martin Salinding, and there is no other person to present
his paper. Okay, we will go to the question-answer question. So, please, for the presenter, sit down to the in front of the room, because many of the audience maybe want to ask some question. I will mention Mr. Joshua, Miss Angel, Mr. Teddy Agustinus Timorang, and Mr. Russell Davis. Please sit down in front of us and sit in our chair we have provided. Miss Angel and Mr. Joshua Harry and Bapak Joshua. It's a question answer session. Please in front of us. Mrs. Angel, anyone knows how where she is? She's gone. Okay, we have already have two great presenter here. Oh, Pak Edi sudahnya bukan flight. Tadi kan sudah flight, sudah terbang. Oh, Pak Edi. Okay, Pak Edi, is it time is enough to have answer question? Yeah, okay. Bapak Raden Edi. Okay, we have already three amazing speakers here. Bapak Joshua have already discussed about renewable energy project. Bapak Russell Davis have already shared some experience in Singapore about waste management regulation. And Bapak Raden Edi also have some talk about how to make better regulation about how to regulate our land, yeah, because there is degradation of land in our country. So, ladies and gentlemen, please raise your hand and don't forget to mention your name and your affiliation. Please, maybe not only question, maybe you have some talk to share with us about maybe some recommendation or some summary or review. Okay, Ibu Intan is very honored to us because she is a PIC of this conference. Also, an honorable Bapak Vice Dean, Bapak Maradona, has attended to this session.
I thought the Bu Indria who is going to address the question after me. Okay, yeah, I have many questions basically, but I'm not going to dominate the Q&A discussion, so I will share. But I have a question for Russell Davis that you are comparing Indonesia waste management control with the Singapore, which is actually why you are comparing with Singapore, which is that we know in any way Indonesia and Singapore is uncomparable, right? Because first the structure, and the second the legal implementation, and also the system, the legal system is quite different.
The amount of population.
The amount of population, see, that's because if we are talking about the waste, let's say I am littering in one day 1 kilogram, okay, and we have 300 million people in Indonesia. Yeah. So if every person in Indonesia littering 1 kilogram a day, 300
million kilogram a day in Indonesia. But you compare to Singapore, how many people in Singapore? So that's the thing that I'm bugging my head. That's why you are comparing with Singapore.
Singapore is like Surabaya in
Yes. Yeah, that's the thing.
Surabaya is still bigger.
The population and also the...
Yeah, indeed. So, well, my expectation is that the comparison maybe with the similar country with not... we have 300 million people, so the comparable is with European Union, yeah, 500 million, but it's not possible. So the question is, yeah, why you are using Singapore?
So first of all, regarding why, I think there's multiple aspects why it might look like a far-fetched comparison to compare ourselves with Singapore. But I think, one, if we actually want to become a better nation in doing anything, we have to compare ourselves with those nations that are already developed nation. And regarding why we choose Singapore in the first place is how it's very close to us, meaning that environmentally, anything that they're doing is feasible to be done also in Indonesia. But secondly, is regarding why, how is it a fair competition, or how is it a fair comparison if Singapore only have a couple million population, but Indonesia have 300 million population. It's fair if we're talking about percentage. So the amount of waste that's actually being processed in Indonesia, let's search it right now. The actual percentage is, wait, I'm sorry. So the actual waste that is recycled and managed in Indonesia is very low. It's in the amount of 14.58%. If we want to compare ourselves with other countries, one, we should compare it to countries that are already developed to ensure that, okay, we see how they're developing, we can implement some systems that are good in other countries that are helping them develop in a much better way. That's the first reason. But secondly, regarding how it's a fair comparison is the percentage. Even though, let's say that in Indonesia we have a big amount of population, 300 million, the percentage is still too far to be said that we are as successful as Singapore, because inherently we only process 14.58, close to 15% of our waste. This means that inherently our efforts to manage waste is still very, very lacking in comparison to Singapore. So the inherent percentage creates a much more fair metric in being able to say that if Singapore can actually manage half of their population's waste, why is it that Indonesia is still unable to do that? Because understanding that waste is a very impactful matter, that when there is improper waste management, it create health issues towards our people. It creates a land economic price would reduce if there is more waste in that area. So we believe that in comparing ourselves with a much more developed country, yet they're very close and geographically they're very similar to Indonesia, we can ensure that, oh, the systems has implemented is somewhat similar and can be done, and the amount of money is feasible for us to be able to do it. So that's why Singapore is something that we chose. And yeah, thank you very much, Bu.
Okay, Bu Intan, maybe another opinion or argument?
Yeah, this makes sense. This makes sense. This makes sense if you are basically comparing the with the Singapore. Perhaps it's not comparing, but you just want to give an example for how to basically to manage the waste. So or waste management control. So whether in your paper you are also illustrating the waste management control not only in a legal perspective, but of course maybe for the social and economic perspective. Whether do you also explain how the waste management control, or at least waste management in Singapore and also in Indonesia also being viewed or being seen from the other angle, from the other perspective, like economic, for example, or social?
I think in our paper we didn't fully go into economics or this, but in the social we did some, but inherently I think economically we have not explored it very much in the paper, because we understand that it's going to be a talking regarding whether or not we have the economical capabilities to accomplish the challenges that we have, which I think it's not going to be an interesting paper if everything that we propose is going to be not possible because we're not economically good enough to be able to access certain things that Singapore can. So that's why we chose not to dive deep into the actual economical aspect, but regarding social aspect and of course the legal framework, we dive a little bit deeper than economy, because we want to understand that I think we as a collective believe that it's very, very beneficial for Indonesian people to be able to have a river that is clean, a household that is free of bad trash and waste. So yeah, that's why we dive much more into social and the actual legal framework to be able to achieve all of the challenges that we have. Thank you, Bu.
Yeah. Maybe Mr. Russell Davis have a dream because Singapore is a great patron to how manage the waste. Yeah, maybe it can apply in Indonesia. Okay, that's your dream. Okay, maybe another participant, Ibu Indria Wahyuni.
Okay, thank you so much, Dr. Fiska, as a moderator. These two presenters present very interesting papers, which I see it now, and it's very difficult for me to raise only one question. So I would like to address to Bapak Joshua Heri, as we discussed yesterday in our presentation, but there is a problem about this renewable energy, right? But in this paper, it's very interesting. You put good governance in climate change policy toward NZE, different with the last paper that you presented yesterday. And you put a link between good governance in climate change with renewable energy projects. The main questions that always become a barrier for renewable energy development is renewable energy is expensive, takes a lot of effort, a huge technology. So do you think now Indonesia has the capability to develop their own renewable project, which inside of it will be implemented good governance in there? Or do you think for pursuing this, we still need to get investment, a lot of investment, like we do it now, you know, chasing investment to all over the world, but at the end, how we can ensuring this concept of good governance that you deliver in your paper can apply in there? Because when we chasing the investment, means we are in, you know, somebody who asking things, right? So the investor, to some extent, have a bit slight better position than us, yeah, the better position to determine something. I think that's what's happening in oil and gas as well. So the question is, how is this going to be happen? What kind of mechanism that you deliver, try to deliver in your paper, Pak Heri? Thank you.
Okay, thank you for your question. First of all, I would like to answer your first question. related to good governance. Good governance in this term, I would like to put it into how the government changed the policy approach. That's the first one. Why? Because in climate change regime, we don't put most of the burden only on the state responsibility. But we try to shift the, not to shift, to share the burden. And as we know, non-state actors like corporations play dominant roles in climate change regime. For example, based on Royal Dutch Shell, it's about how Royal Dutch Shell should be responsible first from the energy that they produce. The second one, Shell should be responsible as well when they sell their energy or their products to another entity. And the third one, Shell also responsible for the consumer that use their product. From this case, we can learn, oh, corporation plays a role in climate change regime. So it's not only about the investment itself, but how the government itself share their duty, their obligation. Oh, we should aware about climate change. But unfortunately, in Indonesia, we still hope that we can get lesson learned from that case. And I believe from a private law perspective, the Dean, Pak Iman, because we met in a conference last month, he also presented about Royal Dutch Shell. The second one, how do we apply this policy changing into a good investment role model or mechanism? The first one is, I think, we should put two systems. The first one is we should phase out the fossil fuel energy. While we phase out the fossil fuel energy, we should give like incentive. I would like not to say incentive or something, but we should allocate into renewable energy. But as you mentioned before, it is high tech, high cost, and something else. But European Union has funding project, and we can use that to cooperate. Oh, we can promote a renewable energy project through investment. And from my basic research, I would like to address, we need to do the just energy transition. It means we have to set up a target, because NDC target is 2030. It's about 6 years and a half, I think, from now. And mathematically, in reality, I'm not sure if we can achieve the NDC, but at least we try. At least we try, and we can measure, oh, this is 0, oh, this is 3 or 5. Oh, our target is 7. Oh, okay. We can assess our policy. We can assess our policy, oh, towards net zero emission, oh, how fast we can accelerate to achieve this one. And with just energy transition, we can, we should consider the incineration, inertia. Inertia means that when you try to move from this side to this one, how long it will slow down, or how fast it will go. So economics will play a major role in this aspect, and I think tax is very important, because in climate change regime we have two mechanisms: cap and trade and cap and tax. Cap and tax maybe is preferable in developed countries, because if it's cap and trading, it will lead into misleading, such as carbon offset. Somehow I think carbon offset is not pretty good enough for Indonesia, but we still need to do carbon offset. And what is your last question?
I think it's already a touch on those questions that you raised And if I can, like, give punch back respond on that. Yes, I do agree with all your statement. And then I think we still have a lot of opportunities, especially like REDD plus, for example.
Okay.
I don't know whether you already touched that on the paper as well, but it is also opportunity. Ma'am, can I connect that question to another question?
Yes,
or
sure.
perhaps, yeah.
It's okay.
So
One more
yeah,
question.
okay, thank you. Pak Heri, the last statement that you said is we can achieve this, and then we already have NDCs, and then for 6.5 years, and then we can achieve this. But I would like to link the NDCs with the policies that are taken by the government. For example, in palm oil, like what Pak Eddie's statement that palm oil is now, although in other continent is forbidden, right? And they said that we killed all these endangered animals because of the palm oil. But on the other hand, the government tried to improve palm oil in terms of renewables. And this is also caused a problem for the farmers. We know previously, in just recent days, there is the farmer got impact because the declining of palm price. And as you mentioned as well, palm trees, palm plantation can cause dangerously, I mean, I have to highlight, dangerously harm the environment, especially for the soil, degraded the land quality. So I see there's a contradict in here. In one side, Harry take that we will have to achieve this NZE. We have to get low carbon development initiative. We have to do this development in a sustainable way. But on the other hand, the government also pursue a policy in palm oil plantation, which we know that also causes trouble in our environment and our sustainable. So I would like to ask Pa Eddie's opinion on that, whether he also put that notion on his paper. Thank you.
In trilemma energy, there is availability, sustainability, and also the production. Yeah, I mean the availability, supply, also the sustainability. This in our country is not rely on the fact, yeah, that we have land, large land, but we also need oil, yeah, for the crude palm oil, renewable energy, yeah, renewable energy. But land make land degradation, yeah. If we enlarge the production of CPO, it impact land degradation. It's a trilemma energy. Yeah? So also we need some income from the export CPO. Yeah? This need regulation. Which priority we must sell outside or fulfill our needs, yeah, for renewable energy, especially if we meet the energy mix. Yeah, if we see the energy mix from 20 years ago until now, we just moving only 5%. If we have a target 25%, it's impossible. Yeah. Renewable energy is difficult, suffer in Indonesia, especially about the supply of CPO, previously is Jatropa, and etc. Government difficult to get the solution of the renewable energy, especially oil. So trilemma energy, we meet some difficulties to fulfill the supply of renewable energy here. If we prioritize to reduce the land degradation, different solution, different regulation, so it's up to government. Which choose?
It's very complicated, because there's a political will of government. We needed that. Okay. Okay. Thank you.
Thank you, Pak Edi. Thank you, Pak Hari.
Thank you.
Okay. Maybe other audience or participant will ask some question or maybe share some opinion.
Can I add some recommendation for him?
Okay.
Okay, because you mentioned some of economics from Chicago School of Thought, like Joseph Stiegler or Richard Posner. Why you don't consider Michael Porter, as we know as Porter effect? If you cannot comply to the regulation, you have to innovate, I think. And it is important to pay attention to precautionary principle, because in precautionary principle, the lack of scientific certainty is not the reason for government to take action. So because precautionary principle has three aspects: environmental, economics, and social aspect itself. That's my suggestion. Thank you.
Yeah, sorry, I add, So the poster, Michael Porter is advantage theory, advantage theory.
No, it's not Richard Posner, but Michael Porter.
Michael Porter.
Different one, different person. So it's I think it's before Richard Posner.
Posner, previous
previous to Richard Posner, because Posner is economic analysis of law, but Michael Porter is about strict environment standard or regulation. And he said that, okay, if you're a corporation that your field is about crude palm oil, ISPO, somehow she said that, oh, it's not really renewable. In the long term, it has negative impact on the environment. And I think if you cannot comply, you have to innovate. You cannot comply to the regulation. So you have to comply through technology, I think. Yeah.
Okay.
So besides the good regulation, we need some innovation, to make it a balance,
Yeah, and you can count the cost of the technology requirement or the cost by using like cost-benefit analysis, or if you like to a regulation approach, you can use regulatory impact assessment or something like that.
If I can jump to that discussion as well, and moderator, I think there's a lot of regulatory impact assessment that we can have, and as you mentioned, precautionary principle, and we also have, actually, if we do it correctly, environmental impact assessment.
Okay.
Yes. Correct.
So if those instruments conduct correctly, we don't have to say that this is dangerous or not. Of course it's dangerous, but as Pak Heri said, we do have advanced technology now. So that is part of the company responsibility to always develop themselves and improve the technology, and then it can reduce what's happening in palm plantation, of course. I think there's a lot of cases that talk about it as well in a foreign as well. There is a lot of big companies that already develop a huge technology. CCS US is one of it, and then there's a lot of technology that we can develop for that. Thank you.
That's a really innovative discussion also, because we have a a lot of knowledge and sharing experience from all of the researchers here. So maybe any question or some, maybe, so if there is no question, please give a big applause to our presenter. Amazing discussion, a really dynamic discussion. And I hope all of us have a dream that Indonesia be a better country, yeah, with a better nation and better regulation. Okay, thank you so much. I hope you enjoy this session discussion, and thank you so much for your participation and contribution, and we will see in next event. Thank you so much. Good afternoon. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you. Thank you. Ya.
Once again, thank you so much for the moderator for such an exquisite discussion, as well as the presenters. And as the second panel session for today is already finished, now we're heading to the closing ceremony that will be conducted by our Honorable Vice Dean, Dr. Maradona. And it will be also my last sentence here. So therefore, I would like to express my gratitude to the plenary speakers, and then to participants, to the presenters, and organizing committee and volunteers as well. And this is not the end, it's just the beginning of our relation, and let's stay connected and continue exchanging ideas, and let's work together in the future. And thank you so much. Now I would like to give this forum to the Honorable Dr. Maradona. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. Ladies and gentlemen, all participants and presenter of our ICLGG. So, ICLGG 2023 organized hybrid by the Faculty of Law Universitas Airlangga will soon conclude. It is our great honor to spend the past 2 days with colleagues from different universities, different countries, both online or offline. With your participation, the ICLGG 2023 successfully finished all its session. On behalf of the Faculty of Law Airlangga University, I would like to extend our highest respect and most sincere gratitude to the joint effort of all the distinguished speakers, presenters, moderators, participants, and also committee. Our most cordial congratulations on the success of this ICLGG 2023. During these 2 days, we all had a fruitful discussion in this fourth ICLGG with the theme Sustainable Development Goals and the Road to Crisis Recovery in Asia. We have learned a lot from the panelization and parallel session delivered by the fantastic invited speakers who have shared their exciting work. Once again, on behalf of the committee, thanks for delivering such essential material so that all of us can deepen our knowledge on the issue of the challenge of sustainable development. Furthermore, I thank all presenters and participants who have joined this conference worldwide. I'm confident that every presenter has presented their best paper. Through your presentation and discussion afterward, all of us can contribute to solving the challenge of sustainable development. Even though the contribution may be small, it is still valuable. The ICLGG will continue to serve as a forum of law and governance stakeholders in Indonesia and beyond to bring together ideas in promoting and developing law to respond to the growing need for guiding solid principle in a borderless world. To conclude, there is a peribahasa or an old Indonesian saying that every meeting has a parting. Happy hour are always so short. Even though it is conducted hybrid, I hope this ICLGG 2023 will leave an unforgettable impression on all the participant guests. I hope that all speakers and participants can enhance friendship and strengthen cooperation to make joint effort to push the sustainable development goal forwards. Finally, I thank all the committee members for organizing this conference and ensuring it proceeds smoothly. I would like also to apologize for any inconvenience that you might experience during this conference. We look forward to meeting you again at the Faculty of Law Sri Lanka conference next year. We have planned to have international conference related to legal education for the next years with joint cooperation with Dean Association of Australia and Korea. So we have time to meet for next years. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much. And before we close the session, and then also before we go to the coffee break for enjoying the last coffee break in our event, and this is not the last because in 2 years we're going to have another ICLGG. Then as a director, I will also invite you again for the next 2 years ICLGG. For the token appreciation for all the presenters who stay from the beginning of the day, of the first day, and the last minute of the second day, we are going to give directly the certificate as a token of appreciation. Of course, first, going to call Raden Edi Suwandono, and then, would you like to just call it? And then Oheo Kaharis, and Joshua Hari, Teddy Agustinus Situmorang, and Russell Davis to come to get the certificate as a symbolic appreciation from our. Thank you very much, and applause. And before we are going to have a photo session, but before the photo session, I also would like to thank to the online participants, online presenters. I hope next 2 years the online presenters will come to our university and then present a new research, a new paper with a new theme another 2 years directly in our the 5th ICLGG 2025. So last but not least, please all the participants to come to in front, and we're going to have a photo session. And also for the online, maybe you can also open your cameras, or perhaps we can have a photo session together. Yeah.
So this is the end of the session, the end of ICLGG 2023. For the offline presenter, the certificate is available in the registration table. For the online presenters, the certificate is available in the website. In your dashboard, you can download your certificate. And for the non-speaker participants online, the committee will send the email. And for the offline, the certificate is available in the registration office. Thank you very much. Thank you again. And see you again in the next ICLGG.